Okay, we now have a quorum and we'll begin the closing the Justice Gap Working Group meeting. This meeting is being recorded. Before I start the roll call, I'd like to ask anyone who would like to give public comment to indicate that they would like to do so by using the raise hand function so that staff can get a sense of how many people we have. I'll take the roll call now. Justice Duker?
Here.
Mary Baldwin?
Here.
Becky Sandifer? Marta Alkenbrock? Andrew Arruda?
Here.
Judge Irma Asbury? Judge Wendy Chang?
Here.
David Engstrom?
Here.
Tom Green?
Here.
Dan Grunfeld? Eric Helland?
Here.
Kathy Huang? Micah Star Liberty?
Present.
John Lund?
Here.
Kevin Moore?
Here.
Wendy Mussel?
Here.
Kristen Passmore?
Here.
Toby Rothschild? Jim Sandman?
Here.
Patricia Scutiero?
Here.
And Satya Steinberger?
Here.
Thank you.
All right, thank you. Well, looking at today's agenda, the first item is public comment, isn't it?
Yes, it is.
So do we have an indication of how many members of the public would like to comment?
It looks like we have 3 so far. You each will have, oh, now we have 4. 4 people, you'll have 2 minutes each to give your public comment, and we'll start with M. Bracamontes.
Thank you.
Hello, thank you for your time. My name is Michael Bracamontes. I'm a civil rights attorney in the Bay Area. And I was just commenting to express my concern for the Sandbox proposal and the deregulation of the requirements for the legal licensure. The concern is that when you open up the possibility of non-attorneys practicing law and giving legal advice, at the end of the day, you're going to see profiteers and big companies. You could get Walmart, Amazon, the Martin Shkreli's of the world in here really putting profits over people. And that runs contrary to the state bar's primary mandate and mission, which is to protect members of the general public. So access is certainly a vital component to justice in our system, but that can be accomplished in other ways in terms of funding legal aid societies, experimenting with having law students take a greater role in situations where people are not represented or small claims type cases, expanding clinics in and around law schools. We don't necessarily need to open up the practice of law to either artificial intelligence, large companies, hedge funds, and the like. Thank you very much.
Thank you, Mr. Bracamontes.
Okay, next we have Whit Birch.
Good morning, Your Honor. Thank you for allowing me to take a couple moments to speak here this morning. I am a personal injury attorney practicing in Orange County and Southern California, Newport Beach. And I strongly oppose this initiative for a number of reasons. I currently serve as the second vice president of the Orange County Trial Lawyers Association. I've been involved in leadership since I began practicing, now almost in my 8th year of practice. And I just see this as, it may be well intended in terms of increasing access to justice, but I just don't see it actually doing that. I think that it has so much potential to take bad turns. As a personal injury litigator, many of the cases that we work on are cases that are referred to us actually by other lawyers. And these are lawyers who either don't have the skill, the knowledge, or the competence to actually take a case through litigation. It's one thing to advertise and market and get business. It's another thing to provide competent quality representation all the way through litigation, including trial. And so I find myself salvaging cases daily from attorneys who just don't quite have the knowledge, skill, experience, or the interest, quite frankly, to provide competent representation. It's hard to be a lawyer, and it's hard to be a competent lawyer. And I just don't see how opening up the practice of law to individuals who don't go to law school, have not performed judicial clerkships, have not interned, have not sat for the bar, have not studied for the bar, or in any other way demonstrated any appreciable commitment to the cause of justice in California. I don't see how that opening the practice of law up to those individuals will benefit the public, benefit clients who need legal representation.
10-second warning.
So, in addition to conflicts of interest arising, it's not expanding access to justice, it's expanding access to poor legal representation, and it actually exposes the client to being taken advantage of. Thank you.
Thank you, Mr. Birch.
Okay, next we have Andy Katz. Oops, hold on, I lost him. Sorry, 1 second. Okay, Andy.
Good morning, working group members. I'm Andy Katz. I practice primarily employment law in the Bay Area, and I have concerns about the deregulatory approach that's being proposed. I was first inspired to practice and focus my practice on employment law, helping workers who are impacted by wage theft, employment discrimination, or workplace injuries through a law school clinic. And I learned really early in my career how the population that needs to be served the most, what their unique needs are, what kinds of judgments are important for considering, and the skills, really building skills that actually serve and relate to what the service population needs. I don't see that in this approach. I really see an approach that's geared towards maximizing investment, maximizing profit. And that couldn't be further in opposite from what's actually being proposed here. I really think about the lack of any standard of care here, and that is very opposite of what we would normally expect. I can see a way of satisfying that as a platform merely providing, here are some rules that you wouldn't have known about otherwise. And if they've done that, well, then that puts them in a better position than not having any representation at all. The standard of care really needs to be what they're actually marketing to people, which is presumably legal services. And that, I think, would be the right way to measure whether a service provider is providing that standard of care. I similarly also find a problem with the waiving Rule 5.4. There are so many opportunities where I can see this going wrong in the actual delivery of this deregulated sandbox here. There are times when representing employment clients, I have had to think about what's important about my clients' needs that are more important than my business. And that's my ethical obligation as a lawyer. And I expect that if there's going to be a paraprofessional, program or a sandbox program, we have to make sure that participants are really abiding to the highest ethical standards. And so waiving Rule 5.4 deviates from that. I urge the committee not to recommend that.
Thank you, Mr. Katz.
Okay, next we have Beth Mora.
Good morning. My name is Beth Mora. I'm a plaintiff employment attorney in the Bay Area. I practice throughout the state. I spend about 25% of my time volunteering in the pro bono space, assisting low-income workers. This proposal is of great concern, and I am confident it will not help access to justice, but it will harm low-income workers and it will harm access to justice. I have been volunteering in this space specifically my entire career, almost 21 years. And before, while in law school, I was a supervised student volunteering in 3 separate legal aid clinics. I have worked to set up a legal aid clinic in my county with Legal Aid at Work. I volunteer with Legal Aid at Work for 21 years, overseeing law students and myself volunteering in legal aid clinics with Transgender Law Center, with multiple other clinics. We understand what access to justice means. What we see, unfortunately, with low-income individuals is harm caused to them by providing services that they get from paralegals who are uncertified and untrained and not overseen, by individuals who do not have the ethical guidelines that a certified attorney does. This is not access to justice. This is harm. Low-income people still deserve the same treatment and the same ethical, educated guidelines of attorneys. They don't deserve less. They deserve just as much, not reduced standards, not less services, but they deserve just as much as someone who makes over $150,000 a year. They deserve just as much as someone who lives on the nicest street in the nicest neighborhood, not providing less services. Access to justice is justice for all, regardless of how much they make. So what we do is we help encourage pro bono services, donation, and volunteerism. I encourage you to not proceed as planned. Thank you.
Thank you, Ms. Mora, both for your comments and for your pro bono work. Ms. Lee, are there other commentators?
Yes, we have 4 more.
Oh, okay.
Next we have Jeannie Harrison.
Good morning. Thank you for the time to be able to comment. I practice law in Los Angeles. I also do employment law, and I am the president of Consumer Attorneys Association of Los Angeles. While the State Bar and proponents of the Sandbox proposal claim that the program is going to lead to greater access to justice for the underserved, the fact is that there is no evidence that alternative business structures actually provide expanded access to justice for low-income individuals, or do anything other than what has been reported by the Boston Consulting Group in its extensive and thorough analysis of the alternative business structures in the UK. The Boston Consulting Group, in studying what has actually happened and what you're purporting to potentially put into place, which is modeled on the UK program, concluded that consumers have not benefited from the ABS structure. Prices are not lower, quality of representation is not higher. That in fact, what has happened is that business has benefited from the alternative business structures. We know that what happens when corporations are making decisions, because corporations have fiduciary duties to their shareholders, is they have to put profits over people. It is their mandate to put profits over people. We are greatly, greatly concerned that this committee is considering such a low standard, which is no standard of care for the Sandbox participants.
10 seconds.
And we urge you to choose not to harm consumers and low-income individuals by making it a free-for-all for businesses to go after consumers. Thank you.
Thank you, Ms. Harrison.
Next, we have Danny Abir.
Good morning, Your Honor. Thank you for allowing me for a minute to speak. The common denominator of everybody who is making comments is that everybody is a consumer lawyer. I'm a consumer lawyer as well. I've been practicing law for over 25 years in Los Angeles. Consumer lawyers charge on a contingency basis. So when we're talking about closing a justice gap, we are not, or consumer lawyers are not the ones who charge clients in order to see them or in order to solve their problems. What this will do, what changing the laws will do, would allow the big four accounting firms, which outside of the US are the biggest provider of US of legal services. And they make 50 billion, Deloitte and Touche, Ernst & Young, 37 billion, PricewaterhouseCoopers, $43 billion, KPMG makes $29.22 billion a year. That's just last year. Opening the basically practice of law to non-lawyers would allow the big four accounting firms to practice law in the US, will allow the big tech companies such as Amazon, Google, and LegalZoom to hire lawyers and do that. But most importantly, what it's going to do is it's going to allow insurance companies to own law firms. And if you go back and look at the alternative business structures and what it has done in the UK, it has destroyed consumer law when it comes to that aspect of law. You will create basically two classes of legal services, one for the rich and one for the poor. And the one that is going to service the poor is going to be the paraprofessionals that you're putting in place. And there is going to be conflicts of interest like you can't believe. How do we resolve this? Educate the public, limit this paraprofessional program to family law, bankruptcy law, landlord-tenant issues, and potentially see if we can change the law to give right to counsel in certain areas of law, so those who are not able to afford an attorney can be given an attorney in those areas as well. God knows there are enough lawyers out there who can help people. A lot of them are out of work. Adding that is not going to help. I appreciate your time. Thank you.
Thank you, Mr. Abir.
Okay, next we have Rhett Francisco.
Good morning. Thank you for the time to be heard. I appreciate the brief opportunity. I practice law mainly in Los Angeles and Southern California, but throughout the state of California. I am also a consumer attorney, primarily out of the employment area, not unlike Mr. Katz and Ms. Mora, who spoke earlier. I think this area is an area of particular concern in light of the fact that there are so many violations, which is why we have our Private Attorneys General Act in the state of California, which allows us to pursue cases that the Attorney General doesn't have time or the resources for. The concern here, I think, is that the bar's main charge or purpose is to protect the public and not open the public up or expose the public to bad things. And the real concern that I think we have is that this project won't increase access to justice primarily, but will actually increase access to predatory business practices on the most vulnerable people in our communities. Employment law specifically, because that's my area of expertise, is nuanced. And even attorneys don't understand the area of law. With 1542 waivers and things like that, which are going to be inevitably within settlements, these people and the consumers and the people who are most vulnerable are going to be subject to waiving massive rights that are going to be completely overlooked by those who are untrained, not professionals, and unskilled, and not familiar with the case law that interprets the statutes in our state. And at the very least, there should be a threshold level of demonstrated competence, not unlike the baby bar, for any specific area. And to close, just for instance, if it's in the employment law area, it should be that there is a demonstrated level of competence specific to employment law, and that person or entity should be limited to employment law only. And they should have to show competence in each and every area that they want to participate or practice. Thank you.
Thank you, Mr. Francisco.
Okay, next we have.
Mimi, I'm sorry, I have my hand up and I don't want to interrupt public comment just a sticker, but it appears to me that several of these comments are really about the proposal that's coming to the board on the 23rd to license paraprofessionals in California. And I just wanted to clarify, we only have one remaining public commenter, but that this group has not generated that recommendation. And that if people want to make public comment regarding that topic, the appropriate venue is the board meeting on the 23rd. So sorry to interrupt, but I had my hand up for that. I wanted to clarify.
Thank you for the clarification. Okay, one more public commentator, I think, Mia?
Yes, we have Antonio Castillo.
There we are. Good morning, everyone. I am a trial attorney based in Los Angeles. I do civil plaintiffs as well as some criminal defense. And I have heard a lot of talking points regarding the concerns of large corporations coming in and doing what they normally do in other areas and prioritizing profits over the potential for harm. I see that firsthand in my products liability cases and rideshare sexual assault cases. However, what I would like to speak on is what I feel the demographic that the State Bar is at the very least attempting to assist with this proposal. And that is a demographic that typically involves low income, low education, the immigrant class. And this is a demographic that I'm uniquely positioned to speak on because it's my background. My parents immigrated from Mexico. I am the first to graduate college in my family, was the first to go to any sort of grad school like law school. And so I'm uniquely positioned to speak on this because these are my people. I grew up in extremely humble means from a humble neighborhood. And they are already suffering from the blight of substandard legal care by something that's called a licenciado. Licenciados, as I'm sure you're aware or may not be aware, are unlicensed individuals, sometimes paralegals, but often not even then, masquerading as attorneys or informing these ill-educated people who don't know otherwise that they don't need an attorney and they can perform legal services for them. It is something that is a massive blight in the community because you see rates that are horrible, sometimes charging them 75% in supposed legal fees. You see extremely substandard care. You see people very much harmed by this substandard representation. And the removal of Rule 5.4 or any modification to it would essentially sanction this very horrible practice that is already happening and harming my people, my community, where I came from. I understand the desire to increase access to care, but increasing access to legal care is not going to solve the solution if it is not regulated and if certain minimum standard is not met. And this rule action coming into place essentially sanctions the practice, the licenciado, and is only going to make the problem much, much, much worse than it already is. Thank you.
Thank you, Mr. Castillo. I believe that concludes the public comment period. Can you confirm for me, Mimi? Okay, good, thank you. So then we'll move briefly to, I think I get a couple of comments and then we're going to move to the staff report. My comments are limited to giving everybody a look at the agenda we have coming, and you all have the topics we're going to be covered, but we're going to move things around in the order a little bit to accommodate various things. We plan to start with topic A and then skip down to topic I. So we'll do the first and then the last of the topics on the agenda. We will then do the topics that are numbered C, D, E, and F. But somewhere in there we'll break for two reasons. First of all, we're going to break for lunch for half an hour at 12:30, or as close to 12:30 as we can fit it based on presentations. And then we're going to come back after lunch and go back into our agenda until 2 o'clock. Item B on your agenda is a presentation from Justice Timmer of the Arizona State Supreme Court. She will come at 2 o'clock to speak to us. Then we will return to the two of the items on the agenda, G and H, that our scope subcommittee has been working on. So I just want everybody to understand a little bit about what's coming. I want to applaud the efforts that the group made to stick with our plan for agenda items going out on the Friday before the meeting, or I should say a week before the meeting, so everybody has a chance to begin their review and to issue comments that they want the entire committee to consider in writing before our meeting. When I call an agenda item, I will call first on the presenters, and then after calling on the presenters, I will call on those who have submitted comments on that topic. And if I somehow neglect to do that, I want you to call me on that, because that's our protocol, and there's a good reason for doing that, because it's a way of focusing our conversations as a group on the items that people who have taken the time to look at the materials in advance have identified as important for the whole group to consider. So that's how we'll proceed for the rest of the day. My only other comment is that I want to thank a lot of people who put a lot of hard work into preparing for today. In particular, I want to call out the 4 teams of 2 who put together our rules presentations. I'm going to ask, we got some really meaty memos from all of you, and thank you for the hard work that you did there. I'm going to ask you to present on what seems the most topical, important focus part of what you put in those memos for whatever seems to you the right amount of time, something up to 10 minutes on your work in preparation for today, and then we'll have some discussion. But those items are not for voting on, so I'm planning to keep each of those discussions, both the presentation and the discussion, to a shorter period than we'll need for the items where our scope and SAGE subcommittees have put a lot of work into coming forward with some specific proposals where we do intend to vote today on whether what's been proposed or some minor variant of it gets the support of the entire subcommittee. So with that note about what we have before us, I turn it over to Randy DeFontorum to give the staff report.
Justice Tucker, I'm sorry, I hate to interrupt, but I'm going to. I've had my hand up, and I just, before we get too far afield, I just want to say that I think during the public comment portion of our meetings as a quasi-governmental agency, that it's completely inappropriate for anyone, a board member or staff, to suggest that any public comments are inappropriate.
Okay.
That time should be for the people who would like to make whatever comments they make. I don't want us to be seen as interfering with that.
Ms. Liberty, thank you. I think we did allow everybody an uninterfered with 2 minutes, but I do understand the import of your comment. I didn't notice the hands because I was focused on what was sort of a non-discussion portion of our agenda, but we will move to discussion shortly. Before we get there, Mr. DeFontorum, the floor is yours.
Thank you, Justice Tucker. Just 2 quick points. One is a housekeeping point. We have resources at the State Bar's website for the working group. Included there, among other things, are a summary of what we've been tasked to do. What's recently added is a link to the full text of the charter for this working group as adopted by the board when the board established the working group. So if you haven't visited our pages at the website, I encourage you to do so. Check out the new link to the full length of the working group's charter. The second point was actually already mentioned by Leah, and that is an update with regards to the California Paraprofessional Working Group. You might recall that back at the February 19th meeting of our working group, we received a status report providing an overview about the good work of that group. And they are doing something separate and different from what we are doing. They are actually considering the development of a licensing program for non-lawyer paraprofessionals. They've completed their work and they are presenting their report and recommendation to the Board of Trustees at the board's meeting on September 23rd, which I understand is starting at about 1:30, but given all of the activity that goes on, the public comment, et cetera, it's expected that the Paraprofessional Working Group report will be considered sometime in mid-afternoon. And anyone on the working group, our working group, who is interested on getting the latest with that activity is encouraged to attend that board meeting. The specific request to the board is to receive the report and recommendation and to issue it for a 60-day public comment period. That report will also include, and this will also go out for public comment, the proposed rules of professional conduct for the paraprofessionals, as well as proposed standards for sanctions. So as you know, attorneys have rules of professional conduct. Attorneys for their enforcement and discipline have standards for sanctions. Those same types of things are being applied for the paraprofessional program. Just 2 other quick notes. The paraprofessional program is being recommended to be implemented on a pilot basis. And so the report goes into some detail on the proposal to have the program implemented in a phased-in manner. And so it would start with only certain areas of law. I believe the pilot implementation areas of law include family law and housing and some collateral criminal areas. And in the pilot aspect is also geographic in nature. It will be limited to certain areas. Northern California, I think it's Alameda and Santa Clara, Southern California, Orange County. And so all of these things are detailed in the report. And if you want, again, a deeper dive into it, the agenda materials for that board meeting are now posted. And this is item 701 for the September 3rd, 23rd meeting. And their full report and information is found there. The rules of professional conduct are also there, I think, in one of the appendices. And that's all I have, Justice Tucker.
Thank you very much. That's very helpful. The next item on our agenda is to see whether anyone is prepared to make a motion to approve the open session action summary from our August 11th meeting. And if so, to vote on that.
So moved.
Thank you, Mr. Moore, for moving. Do we have a second?
Second.
Thank you, Mr. Helen, for seconding. And do we have any discussion? Seeing none, let's ask Mimi that you poll the members to vote.
Okay, Marta Alkenbrock, Andrew Arruda.
Yes.
Judge Irma Asbury. Mary Baldwin.
Approve.
Judge Wendy Chang.
Approve.
David Engstrom.
Approve.
Tom Green.
Approve.
Dan Grunfeld. Eric Helland.
Approve.
Kathy Huang. Micah Star Liberty.
Approve.
John Lund.
Approve.
Kevin Moore.
Approve.
Wendy Mussel.
Abstain.
Crispin Passmore.
Approve.
Toby Rothschild. Becky Sandifer.
Approve.
Jim Sandman.
Approve.
Patricia Scutiero.
Yes.
And Satya Steinberger.
Approve.
Thank you.
Okay, thank you. So we move now to the first item on our agenda, and I will turn this over to our SAGE subcommittee chairs to lead us in a discussion and possible action on your recommendation.
Good morning, everyone. Crispin, good evening to you. It's good to see everybody. I'm going to lead this discussion presenting this resolution. I hope you've all had a chance to review the memo, and there's 5 bullets in the resolution that we'll be going through. There's also 3 people who made comments about this. Thank you for those. That would be Crispin and Jim Sandman and Wendy. So this issue is the question of the sort of basic structure of the entity. Before I kind of go through those details, let me just try to remind everyone that this is not a permanent change to anything. This is a establishment of a sandbox for a to be determined period of time, during which the whole point of the sandbox is to gather data to find out if there's actually harm being caused to consumers and challenges of those kinds that have been alluded to. So I think it's important to remember that we are not here talking about a permanent change. The other thing probably to make clear here, item 1 of this resolution is something we tend to be, I don't think has been considered controversial, but remember everyone, the legislature has to establish this entity. They definitely play a part in this ultimate process. So while this resolution is about trying to strike the balance between, funding and oversight of the sandbox regulator, it's also ultimately going to be something that would only move forward with legislative approval. So just to walk through these items, and I think what I'd like to do is kind of present about each one of them, Justice Tucker, and see if there's any discussion that people would like to have about that. And then hopefully once we've been through all 5, we'll figure out what kind of sort of a motion that we can entertain, if that's all right. The first item, the sandbox regulator will be established by the legislature as a public corporation or other appropriate entity form within the judicial branch of government, serving as an arm of the California Supreme Court. That language has been pretty static for the last couple of times that this has been through, but I'd just like to see if there's anybody that has any questions or concerns about that. This language about public corporation, I think is intended to follow essentially what the state bar's structure is. So that's how that's been set out. And maybe I should just present on these and then we should see later if there's any discussion. Justice Tucker, I'll defer to how you'd like to proceed there.
That sounds good. Thanks.
Okay. Item 2 went through a few iterations over the history of this resolution as well. And you may recall at some point we were trying to explore alternative funding sources. And at some point we were talking about even being a nonprofit. And ultimately we've come to, the SAGE committee's come to settle on this language to recommend to the group as a whole, which is essentially that reliable initial funding is going to be necessary to ensure that there are indeed adequate resources for that very monitoring and data collection and analysis and consumer protection that I mentioned earlier. So that's how that language has come together. I think the question sort of is unresolved, where and exactly how will that funding come from, except to be clear that we obviously need to be sure there is substantial, reliable initial funding. The third item started out, and I think continues to remain, an effort to make clear that we are not getting into some sort of antitrust problem, and that we are indeed making it clear that the sandbox regulator would be actively supervised by a body of the state, that is specifically the Supreme Court, and would act pursuant to specifically articulated state policy. It also makes clear here that it's the sandbox regulator making recommendations to the court, specifically about licensing and discipline, but ultimately the court will be reserving it to itself the authority over the licensure and the approval of those principles. And then, as you may recall, this language about the court shall exercise that authority as it deems most sufficient and appropriate was an attempt to leave open for the court a structure around how they would actually oversee the sandbox that would maybe be more efficient for them rather than having the entire Supreme Court, assess every recommendation that came up from the sandbox regulator. And then in an effort to address some of the concerns that you'll see in Wendy's comments and that Wendy also raised at our SAGE committee, we have this language in the last sentence that none of this is meant to alter the existing roles of the court and the legislature in regards to the practice of law in California. That's essentially trying to make sure that those boundaries are staying as is. Item 4 is also one that has not been, at least as far as I'm aware, subject to a lot of conversation in the last couple of iterations of this. It really just establishes that structure about the board that would be responsible for the operations of the office, and then a staff that would be more involved in the administrative operations and the day-to-day activities under the board supervision. And then the last paragraph is about the board makeup of the sandbox regulator. And I think that's pretty self-explanatory. I would just mention, and I thank Eric in particular for his help in wording this, but this has gone through a series of iterations to come to this language we now have, which is that there'd be 7 members with the Senate and the Assembly each nominating one of those members and the governor nominating the remaining public members. So that's 7 public members, and then 6 members being nominated by the Supreme Court, which would make for a total of 13 on the board. And then, as you can see, there's articulation there of what sort of roles the governor's nominees need to include and what sort of roles the Supreme Court's nominees need to include. One thing that is not in this proposed resolution, as our committee is recommending it to the group, is a wording around the number of years or months or whatever it is, the length of time that the sandbox would be set up and operating. That's a TBD in terms of where we are with the process. You may know that our Utah court first set up our sandbox for 2 years and later decided to extend it for an additional 5 years for a total of 7. So that sort of decision is one that this group is ultimately going to have to make about the sandbox in California, but that's not in this particular resolution. So that's just a presentation of the the resolution as our committee has recommended it. And I should note, and if I get this wrong, Wendy, I'll ask you to correct me, but I think at our committee level, we had unanimous support for paragraphs 1, 2, and 4 of what you see in front of you. We had Wendy did not agree with the way paragraph 3 is worded as you see it here. And you'll see that she's got some alternative language in her comment. And then I think we essentially tabled any ultimate vote on item 5 because Eric was going to rework the language a bit since that time. So I don't, Mary, maybe you can correct me, but I don't think that we had a final vote on the language for paragraph 5.
Yeah, that's right, John. I did just want to point out, though, that with respect to item number 1, we did add that language that you see here, or other appropriate entity form. That language was not considered by the committee. We added that just to address concerns that had been expressed about whether, a public corporation was necessarily the best way to go. We just added that to add flexibility, but I didn't want it to be misunderstood about, if we don't like it, we can take it back out, but that's what the committee voted on.
Yeah, and thanks for that, Mary. And I guess I just want to close my comments by reminding everyone how far we seem to have come on this, although it's been a long journey. Remember that we had 5 different options at the outset about different ways that we might structure the sandbox, and Dan Grunfeld and Bridget did a great job of kind of summarizing those, and we had a lot of input from Brady in terms of the legalities of those things. So while this seems to be pretty short word, efficient use of words when we get down to this point, I just remind everyone that we have been through quite a lot of variations on this theme to get to what's now before you. So this is what the committee is recommending. And Justice Zucker, I'll maybe, if Mary has any additional comments, would that be the next step?
Mary?
Nothing from me. Thank you.
Okay, then I'd like to start by calling on Jim Sandman because his comment was sort of in the nature of a clarification question. Jim, do you want to pose that for us?
Yes, my comment is about paragraph 5. If you could move the screen down to that. The paragraph draws a distinction between members appointed by the Senate, the Assembly, and the governor on the one hand, and members appointed by the Supreme Court on the other. The Senate, the Assembly, and the governor appoint public members. The Supreme Court appoints members. I'm not clear on what the difference is between a public member and a member.
I'm wondering if maybe we could punt that one to Eric.
Yeah, I'm actually going to continue the tradition probably and punt it to Bridget, just because, but Jim, to your question, that's a term of art, as I understand it, in sort of how we set up kind of regulatory bodies to essentially mean non-market participants. And so we were looking for language. We sort of went around some, we initially, if you remember, had put lawyers, but that didn't really seem right since we could have people who were not were not engaged in the selling of legal services, but might actually be attorneys. And so, and then the second part was, I think to your question, that the idea was that the Supreme Court could appoint both market participants and non-market participants as it saw fit, but to assure that the majority of the board was non-market participants, public members, that we would have the legislature appoint only public members. So it was a way of making sure, I think for antitrust reasons, that the majority of the board was not market participants, and that the Supreme Court would have the flexibility to appoint people with expertise within the market who were. And Bridget, I want to go over to you just to make sure I have this right on the public members definition.
You did a good job of that, but it is a reminder, Jim, that we did have some discussion. What are the professional members? And certainly it's not meant to exclude attorneys from that definition, but we thought rather than specifying lawyer, that maybe it should be a little bit broader than that, as far as who are like the I don't know. It's this part has just gotten so confusing. And so I think I'm glad you raised this because I do think we need clarification on this particular issue. I think as we talked about before, and I don't remember if it was in the SAGE subcommittee or in this larger group, but the way that boards are typically set up, regulatory boards, the term public member is really meant to mean not licensees. So the medical board has 8 doctors and 7 public members who are not doctors. That's very clearly defined. The issue here is if we were to say, 7 public members and 6 lawyers, it could exclude people that might be still interested or active market participants delivering legal services. And that's why now that I'm looking at this, I thought we had some language that was talking about delivering legal services.
I'm going to jump in here and say, this is a process point.
Yes.
In order to be coherent in our discussion, before I call on the other people who put in comments, I'm going to call on people who've raised their hands, provided that it's specifically on this point. I would ask if it's not specifically on this point that you put your hands down until I have gotten through everybody who's put in a comment on some issue of our 5 people. We did previously have some language about legal service providers because we thought lawyers were too narrow. Then we thought legal service providers sounded too much like providers of legal services to low-income folks. So that's, I assume, why there's now no constraint on who the Supreme Court nominates other than this requirement at the end that they be individuals with experience in legal ethics, legal services for lower moderate income Californians, and regulation of legal services, which it's theoretically possible those would be non-lawyers, but it seems to me that the Supreme Court nominees will be mostly, if not entirely, lawyers, even though we don't say that they have to be. All right, on this specific question of that we're talking about in response to Jim's point, Kevin, you had a hand no longer raised. Wendy, is your point on this one?
Yes, it is. It's also encompassed within my written commentary. So first, I was requesting that we take each of these resolutions one at a time, because I think there's a discussion point on numerous of them, but specifically as to 5, I've looked at other regulatory structures in law where the term public members has been utilized, and public members has generally, as was acknowledged, is someone without a license. So as written here, this really excludes attorneys. I think the reference to the medical board is a very apt one, where the medical board has 8 doctors, since of course it's talking about the practice of medicine, and 7 non-doctors. It doesn't make sense to me that we would exclude attorneys, and I think that is the intent here and was part of the discussion, was to exclude attorneys, which is one of the reasons I disagreed. I think it's important, given that attorneys are licensed and they have a great deal of CLEs that are required and ethical requirements. They understand what should occur in this space as to the practice of laws to protect consumers. We also talked about individuals who had ethics experience related to the practice of law or a focus in that area. And I still think that's very important, particularly because the Sandbox regulator is really there to protect consumers and to ensure that whatever ethical rules are in place are actually being adhered to by the Sandbox participant. So I object to the language for that basis that it excludes attorneys. It's not focused on the area of ensuring consumer protections and ethics. Additionally, I understood that the mission of the Sandbox was to serve low-income Californians and historically underserved communities. The definition of low income is, generally speaking, defined in numerous places in law. Moderate income is not. I see that there's a mission creep as it relates to the sandbox and the participants that would be allowed. And I'm deeply concerned about that. So as it relates to 4 and 5 are really part of the same issue or same subject area. I see those as coextensive together. So my comments, while I hadn't objected originally to 4, they really go to 4 and 5. So those are my concerns as it relates to 5, particularly, which I put in the public comments, 2 global issues that I have, which I'm happy to go over now or go over.
So Wendy,
later.
can you hold on to the global issues? And can you clarify your comments on number 5? As I understand this, the public members who are non-lawyers, that's for 7 of the 13, but it doesn't apply to all 13. So presumably the other 6 will be either entirely or mostly lawyers, and they will include what you just highlighted as important about experience with legal ethics. So I'm not really clear on what your objection to number 5 is as it stands.
I think we need to find terms as to public members and members. I share that concern, particularly given that I very recently looked at this for another entity, and public members would exclude attorneys. And so if those aren't defined, I think the default is going to be that it excludes attorneys. And I don't see attorneys as the same as market participants. If you're saying a sandbox applicant, then I understand a sandbox applicant should not be one of the individuals who regulates themselves. I think that's a conflict. I do not see the same conflict where it's an attorney who, of course, by virtue of being an attorney and having a law license, would be a sandbox participant.
Okay, Micah.
Thanks. I have questions about 2, number 4 and number 2. And since Wendy was just talking about 4, I'll ask that question first. The language that says, including licensing and discipline recommendations made to the Supreme Court. My question is this, is it anticipated that there will be legislation granting the Supreme Court authority to discipline non-attorney participants in the sandbox? Because right now, the reason why the State Bar's Board has the authority to recommend discipline is because the Supreme Court can regulate attorneys. But if there are no attorneys involved and we're just talking about, corporations in California, I don't understand how the Supreme Court has the authority to discipline them. And I'd like to understand from the drafters a little bit more about what that means. And then I'll ask about number 2, or I can ask my question about 2 now.
Hold on to 2 if you would. John, do you want to respond to Micah and make the other point you had in mind?
Sure. I'll attempt to do that. I think on the question of regulation and what it is that's being regulated, you're drawing a distinction, I think, Micah, between lawyers and non-lawyers, as though that is the line. I think the line is whether what the person is doing is practicing law or not. And there's a lot of people that try to define the practice of law and find themselves tied in knots trying to do so. I mean, real estate agents practice law in the form of completing contracts, but the Supreme Court, I don't think in California, regulates real estate agents. So there are these, if you will, sort of artificial distinctions that are already there. But I think the heart of the matter, to address your point, is the Supreme Court regulates the practice of law, whether it's law being practiced by lawyers or law being services provided by somebody else. And if it amounts to forming legal judgments and giving people legal advice, that would be considered the practice of law. And in my understanding of it, subject to regulation by the Supreme Court, of course, with all the attendant legislative oversight of that, just like is already the case with lawyers.
So,
Hold on. May I ask the State Bar staff restore the screen we were previously looking at?
thank you.
Go ahead, Micah.
So do you then anticipate that all the rules of professional conduct, which is the body of statutes, for lack of a better term, rules that give rise to attorney discipline would then apply to corporations that are not law corporations under the State Bar Act and the Corporations Code?
Well,
I think the answer to that is no, not in its current form.
Right.
But if I can move us back to number 5, which we were discussing. Any further comments about number 5?
Justice, I did have my hand up about that as well,
Okay.
if I may. I think there's a premise here that it's only the lawyers who could possibly be able to protect consumers' interests. And the obvious, I mean, obviously that's not true. I think part of the whole purpose of public members is to both protect consumers and strike a balance between the interests of the lawyers who have their own self-interest in what would or wouldn't happen with the interests of consumers. So in my view, having public members and having them slightly outweigh any potential for the number of lawyers is part of the point, is to have a perspective being brought to the oversight of the sandbox that is not just lawyer centric. And that's partly why I support the way the language is here, emphasizing the need for at least 7 public members.
All right, Tom, and then Mary.
I still
Yeah,
had
just
a
a
point
couple
about
of-
number 2.
Hold on, Micah. We're not doing number 2 right now, but we will come back to it. Thank you.
Yeah, just a couple of points on 5. I do think we should be clearer that a substantial number of the folks on this board should be licensed attorneys. It's just a little vague here, and I think we should crisply say that whether it's 8 or 7, that some of these folks and a significant number of them need to be attorneys. That's point 1. Point 2, I think we should include and make clearer the last sentence I commented on a couple of meetings ago, but I do think we want to make sure that this is not strictly limited to legal aid attorneys or folks that, think of themselves that way. I think we have very specific high problem legal areas that we want some expertise on. Family law, preservation of income, the top 3 or 4 that are mentioned in the Justice Gap report. I think we should try and get people with expertise, to the extent we can, in those specific areas to help the sandbox regulator get to good results for people that are clearly underserved. So those are my 2 comments.
Mary.
Yeah, I just wanted to just quickly say, because I'm just want to eliminate or address any remaining concern. As Wendy suggested, there is no intent to exclude lawyers. Lawyers would be obviously eligible as the 6 members nominated by the Supreme Court. And then just to point out again, because I just don't understand, I don't understand the confusion, so I just want to make sure there is none. The Supreme Court's nominees must include at least 1 person with experience in legal ethics, as well as, these other criteria. So I just, I don't, I hope that resolves the objection. And if not, I don't understand the objection.
Okay, Micah, is your hand raised on number 5? Okay, go ahead. And then Kevin Moore. You're on mute, Micah.
Yeah, number 4. I wasn't finished with 4, but I'll wait until people are finished with 5 to go back to it.
Thank you, Kevin.
Yeah, my point on number 5 is really not necessarily substantive, but some people might view it as. We say, we use the word must, that the nominees must include. We're making a recommendation. I don't think we should be using the word must here. We should be using should. This is what we think, in our estimation, is the best I don't know how you would exactly, how it should be comprised, how the board should be comprised. We're trying to give you some guidance, but, to say this is what you must do, I would just say, this is what you should do. I think that should go far enough. And I don't like the word should, writing disciplinary rules, unless it says must or shall. It doesn't have much meaning, but I think we're making recommendations. And where we just are making recommendations, we should use the word should.
Okay, Neil, if it's on number 5.
Yeah, just to follow up on Mary's comment and Tom's, I guess, to some extent as well. I always read this as meaning 6 attorney members nominated by the Supreme Court. And, I think that's the intent there. At least certainly that's what I was reading it as. So.
Okay. And Micah, is your hand still raised or is that a vestigial?
No, it's still raised. I still don't understand on number 4 where the discipline function comes from. What authority, whoever drafted this language, what authority? Is it a new statutory framework?
So I can answer that by saying that the intent is to have the entire project of the Sandbox something that the Senate, that the legislature, Assembly and Senate would authorize, and of course the governor signing off. So I think that, I hope that will sufficiently answer your question. What exactly does that statute look like? Well, no one's written it yet, but the intent is that the proposals we are making, if they are to go forward after the legislature embraces them and writes and passes a statute enacting them.
Okay, when we're ready for 2, I have another question.
No, we got that. We'll come back to that. All right. Are there other? So I've heard 2 suggested changes on 5. Kevin's kind of narrow point that must should be changed to should, or perhaps to shall. Maybe instead of 1 should and 2 musts, we have 3 shalls. I don't know. But I think that's a language issue that we probably don't want to have further debate and discussion on, except in an offline way. But I hear a more substantive concern that we should modify number 5 in order to specify that the Supreme Court's 6 members shall be attorneys, because otherwise it's left unclear and is confusing. And I don't know whether that's something that a majority of the group supports or not, but I do hear that as a theme that several people have raised, and that we may need to have a vote on. I'm not sure. So any other comments specifically on number 5? And then I'd like to wrap this up and move to, let John move us to other numbers. Well, no, I guess it's actually on me now because I've got to call through the other comments. Anything else on 5?
Justice, I just was going to say, I think to respond to Kevin's point, we use should throughout paragraph 4, and it may be fine to just use should in paragraph 5 as well, to have it flow a bit more consistently there. So that may be a useful approach.
I'm going to leave that for the co-chairs to make final decisions on.
And then I just, I don't know personally that I have any heartburn with it being clear that the Supreme Court's nominees are attorneys. I just don't know if that's what the Eric and Bridget who put this together were intending, or if they were intending to leave it open. I mean, there is this prospect that somebody could be providing legal services without a law license, and therefore could be one of the people that the Supreme Court chose to appoint. That's sort of, a chicken and egg problem, but that's really my question there. It sounds to me like we ought to get that clarified one way or the other.
Well, I think it'll probably be up to whoever it is who chooses to make a motion, what the motion will look like, because I just wanted to flag it as an issue. All right.
Justice Tucker, I've had my hand up. I didn't know if you had seen it.
I don't see you. Go ahead.
Thank you. Just to be specific, I think like the medical board, attorneys should be in the majority, just like doctors are on the majority in the medical board. There was discussion and there was not agreement that attorneys should be in the minority. Secondarily, I am requesting that the terms public members and members be defined. I also think moderate income should be omitted. I agree with the change in the language to should.
Okay. Eric, and then Kevin, and then Andrew.
Just one point of clarification. We struggled a little bit when we say attorneys versus market participants. I know this is the economist perhaps splitting hairs, but I could see public members who are attorneys, you know, that are not necessarily participating in the market selling legal services. So what we struggled with in sort of writing this with attorneys or not is, I guess in some sense, to me, the distinction is, are you selling services in the broad, what I'll call legal services market? And so if you had someone who was, say, a law professor, they might well be a member of the bar and an attorney, kind of by a sort of broad definition, but they would not be selling legal services in the market. And if they decided to, say, do that as an additional job, then they wouldn't qualify as a public member. So I just raised that as a clarifying question for what we mean by attorneys, because I think here, it describes both, an education and a background. Membership in a bar membership in the bar does not mean necessarily that you are a market participant. So I just raised that as I want to be a little careful with non-attorneys and attorneys.
All right, Kevin, and then Andrew.
Okay, I'm not volunteering to be a member of the board, but as a law professor, I provide consulting services to lawyers, but not to the general public. So I'm not sure I would be or could be considered as a public member, because I do provide legal services to lawyers, if not, the general public or the consumers we have mostly been talking about. The second point I wanted to make, really ask a question, because it's come up already in the meeting, would paraprofessionals, the licensed paraprofessionals, which is the proposal going through, would they be public members? Because they can also be participants in the sandbox. Because when you're talking about this concept of who does the Supreme Court appoint, are they just lawyers, or just, can that also include other people who are providing legal services? And are public members only those folks who do not provide legal services, who are consumers or are potential consumers of legal services?
Okay, Andrew.
I just wanted to say, for this in particular, with the numbers in terms of how many should be lawyers and non-lawyers, I think a lot of what I've heard from the public commentary today, specifically from kind of folks from the consumer kind of groups of attorneys, I think they made some amazing points. And I think part of what they said was that we don't want the public to be taken advantage of. And therefore, I think I'm fine as it is, but I think in line with some of their comments around protecting the public, it's important to have as many public members as possible. So I like the way it is, but we could even increase it. And I think they made some really good points.
All right, Crispin. And Crispin, I'm going to ask you to do two things at once, because you had a one-line comment that you approved of what, of all of these. So in addition to whatever you want to say on 5, if there's anything you want to say more generally, do it now, and then we'll be that much further along when you're finished.
Okay, I think I can go further than that. I think we could dance on this all evening, and I think we've got other more important things to talk about, to be honest. So I just put a motion that we accept the drafting as it is currently on screen.
Okay. I think because we have a motion, I have to call for a second, but I'm not clear, Crispin, are you saying just on number 5 you call for the motion as it is on the screen?
I would quite happily do it for all 5 of them, because I think, this is just a recommendation. It's going to have to go through further drafting before legislation is drafted. It's got to be accepted by the State Bar, we could spend all night drafting this. So I'm quite happy to put a motion that we accept all 5 points.
Okay.
I'd like to comment on that,
Oh,
Justice Tucker.
no, hold on. We have a motion, and I think I'm required to ask whether there is a second for Crispin's motion at this time.
I will second it.
Okay, we have a motion from Crispin and a second from John Lund. So now the motion is open for discussion. The way I'd like to do this discussion is to call on Wendy to address any concerns you have not limited to number 5 about any of these 5 proposals, please.
Initially, I had asked in my comments that we take these one at a time. I think that some of these, there may be little concern, and some there's a great deal of concern. Since there's a motion for all 5, I'm going to take the time to share all of my concerns. I have some global concerns. In the subcommittee, we had a vote, and the vote was about the standard of care. The standard of care that was approved by that vote was as if the individual consumer who is receiving the services of a Sandbox participant did not have any legal services at all. I think that is no standard of care. It's not recognized in the law, certainly. It would also be extraordinarily difficult for courts, including trial courts and courts of appeal, to rule on that.
Wendy, I'm gonna jump in here and say, I thought your written comments on that topic were very interesting and helpful, but I don't think they go to these 5 points that are currently before us. Am I missing something, or is that relevant to one of these points as opposed to other concerns you have about our sandbox?
I think they're relevant to these points. The other issue is that the going back with what is the role of the legislature and what is the role of the court. As members might be aware, I'm the State Assembly Judiciary designee. I am the only designee who represents the interests of the legislature. The legislature expressly has informed me, and I have informed the committee, that they have concerns regarding the structure and the relative separation of powers. Specifically, that it appears that there's overreach that is not lawful in terms of the language as to the relative roles of the state court as well as the legislature. I provided some legal briefing on that. I will tell you that that was vetted by the Assembly, and they feel very strongly about it. I provided language that was also vetted regarding what the relative roles of the legislature are and the roles of the court system, which recognizes each individual role. In that, the court reserves to itself the primary authority over licensure of Sandbox participants who are engaged in the practice of law, while recognizing the legislature's regulatory authority over non-attorneys engaging in conduct that does not constitute the practice of law and the shared responsibility of the 2 branches. And so the edits that I had provided that the legislature is interested in preserves what is the relative roles of the legislature as well as the court system and the Supreme Court. There are some significant concerns regarding separation of powers. One, in addition to the language that was proposed, which doesn't adequately address those relative roles, secondarily, it appears that the plan is for the legislature to simply approve the Sandbox, but not approve the regulations that would apply to each participant, but rather that the regulations that apply to each participant occur on an ad hoc, after the fact basis to be determined by the regulatory board when each applicant comes in. So the applicant, which is present on the application, for which I've also submitted comments, would indicate what rules that they would like to be excused from. First of all, we don't have the power to excuse statutory requirements. We cannot excuse labor code requirements. We cannot excuse BMP, Business and Professions Code requirements. That is outside of the purview of the court, and that you cannot waive the laws that the legislature passes through a regulatory agency after the fact. Secondly, if the rules are approved as to waiver per applicant, that provides the legislature no meaningful oversight or agree or disagree with how the sandbox will actually occur, what consumer protections actually apply, and it does not provide the public any sort of transparency. So if I'm a member of the public seeking legal services and I'm trying to determine to go to an attorney, or if I'm trying to determine if I wish to go to a sandbox participant, I ought to be made aware in advance that I do not have the same protections under the law should I wish to go with a sandbox participant. Additionally, so some of these things that are not expressly in 5 are actually encompassed within the 5 proposals here. So because that's the current plan, as far as I understand it, regarding the relative powers of the legislature and what the legislature would be approving or not approving, I think that is significant, raises significant constitutional problems and separation of powers problems. Additionally, there has been discussion about sandbox participants being allowed to participate in the market after the time frame of the sandbox has elapsed. That's obviously a problem for the legislature, and it should be a problem for any regulatory board. I'm unaware of any other regulatory environment which would allow that, both into the ad hoc nature of rulemaking and what laws would apply, as well as allowing participants without any regulation, which I think actually does raise antitrust issues as well. So those are some of the separation of powers issues. And I really encourage a rethinking of that. Again, I just want to reiterate that these are some of the legislature's concerns that I'm sharing as their designee. Further, I do have concerns, again, about the standard of care, which also dovetails into the ad hoc rulemaking that it appears would occur. Those things work hand in hand. That will result in a failure to protect consumers. It will also result in a failure of proper regulatory oversight. It also indicates a lack of governmental transparency and consumer protection. And frankly, I think that we should not be going full bore as this motion indicates. I think these are weighty, meaty issues. And while I understand that certain participants are very invested in pushing some of the matters through, I think that we really need to pause and make sure that we're doing this in the right way, and particularly that we're doing it for the people we're purporting to do it for. That this is, again, the mission is supposed to be increasing access to justice for those individuals who are low income and historically underserved. Honestly, I don't see, there was a reference to estates. Poor people don't generally have estates. They generally need trusts. So that's an example of mission creep that I've been concerned with. I do have other larger concerns, But I think those are the concerns that are about 1 through 5. Thank you.
Okay, thank you. And we have now heard from everybody who put in comments ahead of time. So I'm going to call on Micah because she's had her hand raised for a long time. And then I'm going to ask that we focus for, well, on any of the comments that Wendy just made, but in particular her comments about number 3, where she has proposed some edits to the language. Micah, go ahead.
Yeah, my question is on number 2, and then I have a comment.
Yes.
And I'll start with a comment. I think that any motion to cut off debate is inappropriate under Robert's rules. If a motion gets made to call the question, I'll be making a motion to table that. If we're going to operate like a proper board, I think we need to adhere to Robert's rules, which I know the state bar follows. I assume that we as a subcommittee do as well. My question about number 2 is I'd like to know how the drafters defined data with respect to the data collection.
Okay, does any drafter wish to respond to that question with information?
I'd be happy to try to clarify that for you, Micah Star. When you say you're asking for a definition of data?
What kind of data? No,
Okay.
not I mean, I know what the word means. I want to know what kind of data does this language anticipate will be collected?
Yeah, I mean, to some extent, we're talking about carts and horses here, and we have to actually get a sandbox up and running before it could be fully articulated. I can share with you, and I doubt you've had a chance to look at the 65-page long manual that we use in Utah, but there's very explicit data requirements. There's a spreadsheet of 15 or 20 different fields of data that every provider is asked to supply. And it's everything from the location of the client to the nature of the service, to the status of the matter, to the dollars involved, to the nature of whether it was resolved successfully or not, to whether there's any complaint. It's those nature of things. I guess I don't know that you contemplate having that be built into this language here, but when I see the word data in this context, that's what comes to mind, is that sort of reporting, if you will, from the sandbox participant of that type of information on a monthly, if not, at least on a monthly basis.
Sure, and I'm not suggesting that it be completely defined, but if we're going to be asked to vote on this, I would like to know what the drafters meant. I'm not on the SAGE committee, so I didn't have the benefit of listening to the debate and dialogue up until this point.
Yeah.
And so
I think so.
I just want to finish my question. Thanks. Is it your assumption that we will be using portions of that 65-page, what did you call it? Handbook? Manual.
Yeah.
For that Utah uses, because that's information that I'd like to know if there's already been a decision or if there's an assumption that we're just going to adopt that wholesale here, and that's where we should get our definition.
Well, so first of all, I do think that James Teufel and Lucy Rica presented on the data collection efforts to the entire working group at an earlier meeting. I don't know if you're able to listen to that, but that was some description of the process. So again, I think there has been some information shared all along here about how a sandbox regulator would collect data and the type of data that they would collect. I think I've posted the Innovation Office manual more than once to this working group for review. I know it's a dense and long material, but I guess I don't think that the drafters of this resolution drilled into the specifics of data other than to adopt the concept that anybody who's participating in this as a participant in the sandbox will need to supply whatever is deemed to be the appropriate data to be able to be properly monitored to be sure they're not causing harm to consumers.
Okay, thank you very much, John. Hold on. I'm going to move it on to other people who've had their hands raised. Brady, Kevin, and Mary, please.
I just wanted to make a point of clarification. The state bar and its board of trustees uses Robert's rules as guidelines, but we are not required to adhere to them. And generally, we follow basic principles, but it's the chair's discretion to cut off debate and have a vote.
Okay, thank you, Kevin.
Okay, I had a question regarding item number 2. We're going to go by item, I take it.
Well, I was trying to go item by item on number 3, but if you, since you have the floor, why don't you say what you're going to say, and then we'll go back to number 3.
Okay, because I thought we were on item number 2. That was what Micah had raised the issue about data in item number 2. And that's, I just wanted to ask something else. I'm not sure what's meant by reliable initial funding. I think reliable means sufficient funding to enable the group to do its work. But I'm a little concerned about the use of the term initial funding, because unless more money is forthcoming, this group, this regulator is supposed to operate for, I think we haven't made the decision, I realize that, for a number of years. So I think we should say that the structure, there should be sufficient funding to enable the regulatory entity to do all these things for the duration or for the lifespan of the sandbox, the regulatory sandbox. We have to have some idea, because do you really want it shut down after 6 months or after a year?
Bridget, do you have a response to Kevin's point? If so,
Yes.
I'm recognizing you, and if not, we'll go back to number 3.
Yes, no, both to Kevin and to Micah, as one of the drafters of number 2, I will respond to Kevin. I think you're right. You know, initially we had some additional language in here about, like, ultimately it could be funded by licensing fees. And so we had this initial funding in there to kind of distinguish that. But since we as a group decided to take that out for now, I think it would be okay myself to take out the word initial. I think the concept is still the same. And as far as data collection, I just wanted to clarify it, just to kind of second what John was saying. That's the whole point here, is that this number 2 is meant to be a safeguard for consumers. So this is not going to be like a deregulation, just go do what you will. It's meant to have sufficient funding and to support things like data collection and other things that will make sure that consumers are protected from applicants that are in the sandbox. And so whatever, we have not contemplated specifically what data that will be yet, that's going to be determined later. But the whole point of the data collection is to protect consumers, and that's what we were trying to get there.
Okay. I would like to shift us to topic number 3, because Ms. Mussel made some specific proposed edits in her comments ahead of time that I think everybody's had a chance to look at. And I think her concerns ought to be discussed and addressed. So if there are other members of the group who have comments on her proposed language on number 3, I think now would be helpful to have you share those comments. So Kevin and then Mary.
Okay, the only, I was a little bit concerned about, and I'm looking at page 2 of the email compilation. I believe that's the changes that Wendy has proposed in bold and underlined.
And I would ask staff to put that up on our screen so we can look at the bold and underlined version that was went out on Wednesday night, please, of number 3.
I have Wendy's version. I just put it right here. Alternate
All right,
version.
go ahead, Kevin.
Yeah, I'm a little bit concerned about what is contemplated by this, because I think it starts by talking about the active supervision of the Supreme Court, similar to how the Supreme Court supervises the regulation of legal practice by attorneys. I'm not sure it would be workable to have 2 government branches involved in the actual operation of the regulatory sandbox. I think that the concept, and maybe I'm wrong about this, and I recognize completely California's unique dual regulatory role of legislature and Supreme Court. It's caused quite a bit of consternation in the past for rules that I've tried to draft on behalf of the state bar with the cooperation of other people trying to get things through, but that's fine. But I think the concept here is that we get buy-in from the legislature that will allow the operation of the sandbox and supervision by the Supreme Court. And I think the Supreme Court alone, because I think that's the only way it's going to be workable, that you can't really report, make recommendations to both and then have these two entities possibly coming down with disparate decisions. I mean, you really need one court, I think. And when I use the word court, just like when you go to court, you don't want to have to go to two separate courts with your matter or your dispute. You want to go to a single entity that's going to make the decision. So I think how the allocation of authority over the regulatory sandbox has to be worked out at the beginning. And I agree that the legislature has to be involved completely on base. I've said that numerous times, Wendy, before you became involved in the working group. So I think it has to be done, but I think it needs to be worked out ahead of time. But we really can only have, I think, one ultimate authority. And the recommendation here is the Supreme Court. If the legislature would prefer to be the authority, I'm not sure how that would work out. That's my comment on this.
So Kevin, I'm going to ask you a question in order to try to make your comment more concrete.
Okay.
There is language in Wendy's proposal where she talks about, and it's about halfway through, it's about recognizing the shared responsibility of the two branches for approval of any governing principles the sandbox the regulator employs. Is that language that Wendy proposes consistent with your is that language that you like or don't like based on the general point you just made?
Well, I'm reading about halfway down. It says the shared responsibility of the two branches for approval of the governing principles. I'm behind that. That's what I'm saying up front.
So you're behind that portion of the language.
Yeah,
is it possible that your concern is more about the first edit where she has added "and the legislature" concerning the licensing and discipline of sandbox participants?
That is the concern.
Okay.
I think you need to have one ultimate authority.
All right, so I just asked you to comment on two specific places of the language. Does the general comment you make require cause you either to say I like something she's added or I have particular concerns about something she's added? I'm trying to point out that it's helpful if you can be specific.
Okay, I'll start by saying what I don't like. That's the third line of the proposal that's highlighted right now in the legislature.
Okay.
I don't think that's workable. Down below, where it's talking about cooperation between the two entities, I think that has always been contemplated. Or maybe it's, in my mind, it's been always contemplated by this working group, which doesn't necessarily guarantee it, that there would be cooperation between the legislature and the Supreme Court in laying out the governing principles of the regulatory sandbox. That was my understanding, is what it was going to be done. We recognized the difficulty because we do have this dual role of regulation in California. So I'm fine with that. If to the extent it means what I just said, there's going to be cooperation at the beginning, but if it's, if you can't get the cooperation where there's going to be one entity that's going to be the ultimate authority, I begin to see that we're going to get into possibly an unworkable situation in terms of monitoring, data collection, and so forth.
Okay, thank you. Mary.
Thanks. I agree with Kevin. I would take out the "and the legislature" on the third line, because I think that just creates not only the problems that Kevin identified, but just an ambiguity. I would probably also take out "primary authority" on the fifth line, because I don't know what that means. Again, it seems inconsistent with what we're talking about. The rest of the changes, they seem, I agree with the leaving in the shared responsibility of the two branches. That is absolutely what has always been contemplated. And if it's helpful to keep that in, let's do that. The recognizing the legislature's regulatory authority over non-attorneys engaging in conduct that does not constitute the press of law. That seems wordy. I'm not sure the legislature does have regulatory authority, but I'm not an expert in that. So I don't think I object to that language, but it seems a little unnecessary. And then the rest of the changes, if it's important to leave them in, I'm fine with them.
Thank you. Andrew, and then John.
Yeah, I was just wondering, it seems like we're still debating the language, which makes sense if that's what direction we're going. But I know that Crispin had brought a motion to vote on the language without the edits. Is that still in motion, or I just want to understand procedurally where we're at. Because
procedurally we're having discussion before we vote, and there may be a request for friendly amendments to be considered before we vote, but I'm going to leave that to people who might make that request after a little bit more discussion. John, you're next.
Yeah, actually, I was just going to suggest that along the lines of what Mary just said, if with what Mary suggested, we could adopt this alternative version specifically to not use the change in the third line, to take out the word primary, and to perhaps fix the wording of the language about the legislature's regulatory over non-attorneys. I'd accept that friendly amendment if Crispin would.
Well, before we get to that, I would like to make sure, Neil, I don't know whether Greg is able to make the call, but my understanding is, I know that Wendy and Greg had a very fruitful back and forth discussion, and that was an important part of Wendy's process, and I think a productive part. And my understanding was that primary was something that Greg asked for and cared about. If he's not available, are you able to speak to that?
Yeah, well, I do think that if we remove "and the legislature" off the third line, then perhaps primary is not quite as necessary. I think that Greg was adding that there because of the addition of "and the legislature" to the earlier part, if that makes any sense.
Okay, got it. And right now, I don't see any other hands raised, but now I do. I see Wendy and Mary. So in that order, Wendy and then Mary, please.
Yeah, thank you. I don't know if it's not showing. My hand has been raised for a while, but
no, the problem is it depends. I only get 6 people at a time, so it depends which, or 8 or something. So it depends which 6 or 8 I'm looking at.
Fair enough. I think there's a misapprehension of what the language means. The legislature, who did provide feedback on this again, is concerned that they have input regarding what rules would apply to the sandbox. So the concern here is that it appears to be the plan is that each sandbox participant, when they apply, the regulator will decide on an ad hoc basis what rules apply to them. What that effectually means for the legislature is the legislature doesn't have any feedback meaningfully regarding what rules and regulations apply, and in the materials that have been provided back and forth in the meetings that I've been involved with, do contemplate waiving rights that there's no legal ability to waive, specifically statutory rights. So I know we have a pending motion. I would like a motion either up or down on this language. I think that this accurately reflects the law as it relates to each, the Supreme Court and the legislature's roles. It also clearly articulates concerns the legislature currently has. And I just want to be very clear about that. The other piece Again, the data collection was brought up as it relates to this language. We did not discuss what that data collection means. And as there's been prior discussion about commodification of client data, that's also opens that up. So, which of course I oppose. So I would ask that, I know we're in sort of which motions are flying here, but I would make a motion that the language that I proposed be ruled on one way or the other.
Okay, so I think what you have to do is you have to ask whether the makers of the motion that are that's currently on the floor would accept as a friendly amendment all of this language, just as John and or Mary have asked whether they would consider a friendly amendment of striking and the legislature and primary and making some edits to the third of the blue text, but then leaving all of the rest of the blue and red edits. Did I get John and Mary's friendly amendment request right? I acknowledge it's got a piece that's not yet tied down, but Micah.
So Brady says that the chair tells us whether or not we're following Robert's rules. And
Okay.
I just want to know one way or another to know how to go forward.
So the chair knows some about Robert's rules, but not everything. So if your question is more specific, I can answer it. But if you're asking, am I going to adopt Robert's rules lock, stock, and barrel, I have to say, no, not necessarily.
Okay, well, I'll just provide a comment and leave it here, and you can do with it what you want. Under Robert's rules, there really is no such thing as a friendly amendment. And so what would need to happen now is someone would need to call the questions on the first motion for an up or down vote, and then there'd be a second motion by Wendy, a second, and a vote on that.
Got it.
Just to help keep things organized, or whatever you want.
Okay. I will try not to be too ad hoc. I want our procedures to be flexible enough to be efficient, but also principled. So what I'm going to do today is say that I'd like to have an up or down vote on an amended version of what was proposed, because it seems that the people who brought us this language, that is to say the co-chairs, are prepared to see some of Wendy's language added, but not the rest of it. So if the person who's made the motion is amenable to that, I'd like to do that. And then we can have an up or down vote if something remains on other language. May I make a suggestion, stepping out of my role as chair and into my role as member, with regard to this third set of blue language, the language that starts who are engaged in the practice of law, comma, while recognizing, and so on. I propose that and so I'm offering as a friendly amendment that we keep much, please just leave it there, that we keep much of that, but that we strike the following. We strike are engaged in the practice of law while recognizing the legislature's regulatory authority over non-attorneys engaging in conduct. Oh, actually, I'm sorry. I wanted to keep while recognizing. Okay, so keep everything through while recognizing. So keep Sandbox participants who are engaged in the practice of law while recognizing. And then I'm sorry, I don't control this, or I could tell you you're a paragraph too low. If you could go up to Wendy's language, please.
Okay. It's the same language, but okay.
Okay, do you see where it says while recognizing?
Yes.
Okay, take out the word, okay, good, except stop at the end of the blue, exactly. So my proposal would be to take out that and then the word and. so that we can highlight. So it goes straight from while recognizing the shared responsibility. That's my proposed friendly amendment. For folks to consider. And the reason that I'm suggesting it is I want to highlight the shared responsibility of the two branches. I think I agree with both Wendy and Kevin that that's a very useful thing for us to say. And in the language that was just pulled out, I thought the idea of the regulatory authority of the legislature was a little bit confusing, because I think of regulatory authority as something exercised by a regulatory agency. The legislature has legislative authority, which is stronger and more vigorous than regulatory authority. But I think of it in different terms. And I thought it was not helpful in the language that I'm proposing we take out to distinguish between the practice of law and the non-practice of law, but rather that we adequately protect Wendy's point about the legislature's role over the non-practice of law by leaving it just in the last sentence, because after all, the sandbox will not be addressing anything that's inarguably not the practice of law, because nobody would go to the sandbox for authority to do what they have authority to do without going to the sandbox, because it's not the practice of law. As, for example, the legal document preparers that Wendy mentioned. So that's a little confusing, maybe, but hopefully the main point of that proposed friendly amendment is there. Okay, John and then Wendy, assuming your hands are both still raised and that's not just vestigial.
So Justice Tucker, as the seconder of the amendment, to the extent that we're going to follow the maybe not formal rules of order, but practice of friendly amendments, which is common, I'm generally fine with what you're suggesting. If Crispin is the maker of the motion, I would note one thing, and maybe this might warrant a slight change in the wording. We have participants in the Utah Sandbox who do lots of things other than practice law. They might do real estate. They might be accountants. And I don't think that we regulate the parts of their business that are not the practice of law. So I would suggest maybe that language be, the court should reserve to itself the authority over licenses of Sandbox participants to the extent that they're engaged in the practice of law, as opposed to the way you have it worded.
Okay, so that's a further friendly amendment proposal to Wendy's language, changed who are engaged to the extent they are engaged in the practice of law. Wendy.
I think that the changes are concerning as to the relative duties and authority of the Supreme Court and the legislature. The legislature does have legislative authority over non-attorneys engaging in conduct which does not constitute the practice of law. So if the concern is a legislature's regulatory authority, I mean, I could see saying legislature's legislative authority, but the legislature is concerned they're getting cut out. And I'm just being very transparent about that, both in the information that I've provided, the briefing that I've provided. There's been actually communications with the legislature. So I just want to be really upfront about that if you want the legislature to approve this, then the concerns that the legislature had should certainly be listened to.
Absolutely. Neil.
So just to respond to Wendy's comment, I thought that the last sentence, as with the additional blue language, still makes clear that the legislature still has that role vis-a-vis individuals that are not practicing law. Right.
Bridget.
Yes, I was just going to say, I think the way it's worded, and especially since we have the language in there that says, this is not meant to alter the existing roles.
Right.
And combined with further communication with the legislature, as we have been communicating with them, we're really not trying to do anything by this that is going to change their authority. We have a long way to go here with a lot of details. And I think we can continue to be in communication with them. I hope that with this changed language and with continued communication with the legislature, that we fully intend to go through the legislative process with a lot of this, including with respect to the policies. The way that this is worded should suffice for now.
So to the State Bar staff controlling the screen, and I guess to Crispin also, because you are the motion maker, the other two friendly amendment requests are to take out "and the legislature" and to take out "primary." And so my question to Crispin is, do you accept all three of those proposed friendly amendments, or do you reject any of them?
I accept them all.
Okay. And John has already accepted them. So I think I would open to further comments, starting with Micah, and then, okay, go ahead, Micah.
I just want to register my objection to removing the language that was just removed. I support everything that Wendy has said about communications and very clear messages that are coming from the legislature. I just wanted that on the record, so to speak.
So that's helpful. And I hope that those of you who are in very close communication with the legislature will also bring back to them the message that we are not trying to, the fact that we take some language and not others does not in any way detract from what I think is the universally held view of this group, that the legislature has the final word. We are only making recommendations. But I will tell you that a number of people looked at the original language, where it had added "and the legislature," and thought that what that language meant was that the legislature wanted to vote yes or no on individual sandbox participants. And if a number of people read the language that way, and that's not what the legislature wants, then that suggests that the language itself is confusing. And that lies behind my being happy to see the friendly amendment to have those the words "and the legislature" removed. Not a desire in any way to cut the legislature out, but only to make clear that the legislature doesn't intend, and we're not recommending that they will be making recommendations regarding the licensing and discipline of particular sandbox participants. In case I'm missing any hands, oh, Kevin Moore's just popped up. Kevin, you're on mute.
Would it help to clarify, Justice Tucker, what you just said by saying that we're not talking about concerning the licensing and discipline of sandbox participants in general, but we're talking about the licensing and discipline of individual sandbox participants? I don't know whether that's a reasonable, that clarifies that we're not talking about designing the sandbox, we're talking about making decisions about a particular sandbox participant.
Well, I don't know that the recommendations from the sandbox regulator to the Supreme Court would be limited to individual sandbox participants. So it may be that whatever that proposal is needs to be fleshed out a little further before it's offered as a friendly amendment. Randy, did you have a comment?
Yes, and it's just a very general comment that like everyone, I value the consensus on the language of the recommendations themselves, but I did want to offer the observation that the recommendations, when they're further considered, when they're put out for public comment, when they go to the board, et cetera, that they will be supported by an explanatory report. And so if certain details or nuances are not appropriate for the language of the resolution itself, there will be the opportunity to add the further explanation in the report that will accompany the recommendations. And that goes for much of everything we do. Just wanted to make that observation.
Thank you, Randy. I think that's helpful. I would like to ask whether on any of the 5 paragraphs that are part of the motion Crispin has made and John has seconded, that we have other suggestions or requests of friendly amendment, or if there are none, whether we are ready to vote. David Engstrom.
I'm not sure that the, excuse me, I'm not sure that the final sentence reads right to me. It says, or the existing role of the legislature regulation of conduct. Is there a, this might be a Scrivener point. Should that say legislature's regulation, legislative regulation?
How about adding in between legislature and regulation? I'll start by asking Wendy, is that what's intended here? And then Chris and John, if they would accept it.
The original said, or the existing role of the legislature in regards to the regulation of conduct that does not constitute the practice of law. So this, it reads differently than what my draft was. And the taking out of and the legislature above, I would deeply oppose, given the ad hoc rulemaking. I think it cuts out the legislature, and the legislature is deeply concerned about that.
Okay. So I appreciate, Wendy, knowing that the longer phrase that you had originally had in mind here was in regards to the regulation. I think we could just say in regulation of conduct and get the same point. Or in the regulation.
Could we say in regulating conduct?
In regulating conduct, sure. So the seconder has proposed as a friendly amendment that says in regulating conduct. Crispin, do you accept that proposed friendly amendment?
Yes.
All right. Other discussion on number 3 or on number 1, 2, 4, or 5 before we, and I guess when I say discussion, any other proposed friendly amendments that would be voted on as part of the up or down package? Kevin Moore.
Yeah, I just wanted to clarify on number 2 that the word initial was stricken or struck.
So Kevin proposes we strike that. Is that a friendly amendment that are?
Yes.
Fine.
Okay. And Neil has a comment.
There's a typo in number 1. Appropriate entity should be from within the judicial branch, not form, I think.
No, I think it was form. It doesn't have to be that. Looking at it, appropriate entity within the judicial branch is also fine. We could strike that word.
Okay, Mary has a friendly amendment to strike form.
Yeah, agreed.
Okay.
Accepted. Good. Any other friendly amendments? Kevin, is your hand vestigial or do you have one more?
Yeah, actually in item number 4.
Yes.
I'm just wondering, I hate to say this, but you're talking about a volunteer board. Should the word paid be put before staff?
I don't think it's necessary if you're just wondering, but if you're asking for it, then we can ask if that's a friendly amendment.
If people think it's not necessary, fine, but I always like to see people properly remunerated for their work.
Amen to that, and our board members won't be. All right, that sounds like a friendly amendment. Kevin suggests we add paid before the word staff. Crispin and John?
I don't think it's needed because volunteer makes clear.
All right, that one was rejected. Any others? John, your hand raised? Nope. Okay. So at this time, I think we are ready to have a vote on this proposed set of 5 on basically a vote on Crispin's motion as friendly amended in several regards. Any questions about what we're voting on before the question is called? I don't want anybody to be unclear.
Yeah, I'm sorry, I do have a question. Are the Supreme Court appointees now attorneys or what? I don't see anything here.
Aha, okay, we did not get a friendly amendment, so I wasn't going to make a change there. But if you are asking that we specify
Yes.
that, okay, then can you try to reduce it to actual text and say what your friendly amendment is?
We're looking at number 5, Mimi.
Okay.
Yeah, I think I'd suggest something like the Supreme Court's nominees must be licensed California attorneys.
You
And
could also
must,
say 6 attorney members.
you could do that, yeah, that's fine too, yeah.
So where it says, and 6 members, it would be 6, you're adding just the word attorney.
Yeah, I think that may be the simplest way to do this.
All right, that's a proposed friendly amendment to Crispin and then to John. Is it accepted or no?
I wouldn't accept it. I actually think that you can have those skills without being attorneys. And I think that I also accept that you could be public members and non-practicing attorneys. I think the Supreme Court probably knows it can appoint attorneys with those skills if it wants to. I don't think it's needed.
Okay. So that one has been rejected.
Okay.
Any other proposed friendly amendments? Okay. I suppose if we, so I think what we do now is we vote on this in its entirety. And then if anybody wants to make an amendment to change what we have just voted on, for example, if Wendy wants to say, and now I move that we make all the other edits I asked for and you didn't accept, or if Tom wants to make a motion that we add in the word attorney, then any of those motions, if they get made, will get voted on, after the fact, and we'll amend what the proposal is. But the question before the House is whether to adopt the motion Crispin has made to adopt these 5 measures. Andrew, do you have a question about this?
I do.
Or comment?
I
Yeah.
just wanted to bring to your attention in the chat, Jim Sandman said that he had to excuse himself for 15 minutes and then said, if permissible, I vote in favor of Crispin's motion. So just ahead of us voting, I'd like to know if his vote will be counted or not.
No, it will not.
It will not be counted, but we are all apprised of that. So if that requires some further action when he returns, because, well, for any reason, we can take it. Okay. Now, Mimi, please call the roll on the motion.
Okay, so the motion is to approve the recommendations 1 through 5 as revised. Martha Alkenbrock, Andrew Arruda,
Yes.
Judge Irma Asbury, Mary Baldwin,
Yes.
Judge Wendy Chang,
Yes.
David Engstrom,
Yes.
Tom Green,
No.
Dan Grunfeld, Eric Helland,
Yes.
Kathy Huang, Micah Star Liberty,
No.
John Lund,
Yes.
Kevin Moore,
Yes.
Wendy Mussel,
No.
Crispin Passmore,
Yes.
Toby Rothschild, Becky Sandifer,
Yes.
Jim Sandman, Patricia Spitiero,
Abstain.
and Sacha Steinberger.
Yes.
Thank you. The motion carries.
All right. Do we have any further motions on this issue area before we leave? Wendy?
I have a couple of motions. The first is that the language that I proposed be approved as it relates specifically to the separation of powers. That's on number 3. And after that, I have other motions.
Okay. Can you combine all your motions into one?
Well,
I don't know what your
I
other
think
motions
some
are.
will may pass and some not. But two, I don't think that we ever got a cogent answer to Micah's data collection, and given the issues that have been raised about commodification of client data, what uses, what scope, I think I would like to take out or table that for additional discussion. It was not discussed in the scope of that in the subcommittee or analyzed. And regarding 4 and 5, my motion would be to have attorneys, the definition of public members and members, and flip the 7 members would be attorneys and 6 could be attorneys or other folks.
Okay. So I would like us to be able to conclude this discussion relatively quickly, but I would like you to be able to have your motions heard and decided. So Brady, do you have a order point you want to raise? You're on mute.
Yeah, I'm just, wasn't the last vote to approve all of these on the screen with the changes, for instance, to 3 that we just did?
Yes, it was, that's true, but I thought that Wendy could still make a motion that we do something additional or different, and it would be.
I mean, that would be a motion to reconsider the vote we just took.
Yeah, I don't think that once something's been approved and the motion carries, you can't go back and re-vote on it again.
Well,
That's my understanding, but I'm not sure.
Are we following Robert's rules or not? I mean, that's part of the issue.
Okay.
I mean,
So, all right. So I said during our discussion that we could have motions after the fact to raise specific issues. I will let any member who wants to make one motion make it, even though that's not perhaps the normal rule. But I think by limiting each member to 1, and I assume many members won't have 1, that should limit the number of motions that amount to reconsideration. So you can decide how broad or narrow you want your one motion to be, but I would ask that there be just 1. Wendy, I'm going to give you a moment to think about that while I just ask the other people who have hands raised, namely Mary and Kevin. Are these about procedure or an indication you want to also raise a motion?
This is about procedure, and
Go ahead.
I voted yes only because of your statement at the beginning. We could
Okay.
revisit it because I wanted to make a motion to make the Supreme Court attorneys. The motion I'd like to make is to reconsider the previous motion if we can.
So Kevin,
yeah,
it's
okay.
because I had made that statement that I feel bound by it, but bringing one motion, you can ask to do exactly that on attorneys. I will give you a chance to bring your one motion, just as I will give Wendy a chance to bring her one motion, and you can decide on the breadth of the motion you want to bring. Will that, I hope, address your concern?
That's fine by me.
Mary, anything you want to say before we can entertain other motions?
Yeah, I just want to address this data collection point that's come up. No, we're trying to proceed here by biting off little pieces to try to make some progress. And this is not intended as the final word or the comprehensive, set of guidance on any of these points. And we're going to have plenty of opportunity to develop this as we go along. And with respect to data collection as used in number 2 only is only referring generally to the principle of data collection as part of regulation, and there's no intention that it is specifically defined. We have so much left to do to define what data, how it will be used. We're looking at something later today on that subject. So to expect a preliminary kind of set of governing principles to lay out every single aspect of the regulation that's going to result is unrealistic. And it's just, we're setting, if that's our expectation, we're certainly doomed to failure.
Okay, thank you, Mary. Wendy, are you ready with the motion, or do you want me to call on Kevin first?
No, the matters that I articulated, I can put in one motion.
Super, let's hear it. What's your motion?
So the motion would be under 1, take out data collection for the reasons previously stated. For number 3 to substitute the language that was proposed previously in its original form. For 4 and 5, which are related matters, that the board there be provided a definition of public member and member, and that it would be 7 attorneys licensed under the state of California, and that the remaining 6 members could be attorneys or non-attorneys, depending upon whatever is designated by the governor and the Senate and the Assembly. And I would also take out moderate income, since we have no definition.
All right, I think I got that all, but let me ask, does anybody have any question about what Wendy has just moved? And then my next question is going to be, do we have a second?
Second.
All right, Wendy has moved and Micah has seconded that we make a series of amendments to the proposal just adopted. Is there discussion specific to this? And I would ask people not to say anything that has already been aired, because I think we're probably ready to vote. But if I'm missing something, raise your hands. I see that Mary's and Kevin's hands are raised. That may be vestigial. Kevin, is it specifically on Wendy? Okay, good. So let's have a vote on Wendy's motion.
Okay, so
Mimi, please.
the motion is the following: to take out the term data collection in 2, to revert to Wendy's initial draft of 3, for resolution 5, change it to 6 public members and 7 attorney members, and delete moderate income, moderate before income. Does that sound right, Wendy?
It omitted that what a member and a public member are needs to be defined.
And for public member and member to be fine. Okay. All right, we'll take a vote. Marta Alkenbrock, Andrew Arruda,
No.
Judge Irma Asbury, Mary Baldwin,
No.
Judge Wendy Chang,
No.
David Engstrom,
No.
Tom Green,
No.
Dan Grunfeld, Eric Helland,
No.
Kathy Huang, Micah Star Liberty,
Yes.
John Lund,
No.
Kevin Moore,
No.
Kristen Passmore,
No.
Toby Rothschild, Becky Sandifer,
No.
Jim Sandman, Patricia Scutiero,
No.
Satya Steinberger.
No.
Thank you.
Real
Motion-
quick, I think you missed the mover of the motion. Wendy wasn't.
Oh, sorry. Oh, sorry, Wendy Musell. Sorry, my bad. So yes, okay. The motion does not carry.
Okay, Kevin Moore, I believe you have a motion.
Yes, I'd like to move that in item number 5, line 3, that the word attorney be placed before the after the number 6 and before the word members.
I would like to second that motion.
All right, are there any questions about what this motion is, or any reason that anybody thinks we need to have further discussion on it, or can we move straight to a vote? Wendy?
We still don't have a definition of public member or member, and I think that's substantive.
Okay. Any other discussion before we move to a vote?
Just a quick, I don't know if Kevin wanted to specify if that's a California licensed attorney.
That would be fine by me.
Yeah, and I would certainly accept that change.
All right, we have a motion friendly amended to add the words California licensed attorney before members nominated by the Supreme Court. With that, I think we're ready for a vote. If you would call it, please, Mimi.
Okay, Marta Alkenbrock, Andrew Arruda,
No.
Judge Irma Asbury, Mary Baldwin,
No.
Judge Wendy Chang,
No.
David Engstrom,
Yes.
Tom Green,
Yes.
Dan Grunfeld, Eric Helland,
No.
Kathy Huang, Micah Star Liberty,
Sorry, yes.
John Lund,
No.
Kevin Moore,
Yes.
Wendy Mussel,
Yes.
Crispin Passmore,
No.
Toby Rothschild, Becky Sandifer,
No.
Jim Sandman, Patricia Scutiero,
Yes.
Sacha Steinberger.
No.
Thank you. Let's see, hold on, 3. Motion does not carry.
Can you tell us what the final vote was in numbers?
Yeah, for the yeses, it was 1, 2, 3, 4, 6. And for the noes, it was 4.
8.
Sorry, not 4, sorry, 8. Sorry, 8. 6 and 8.
All right. Got it. Thank you.
Sorry about that.
Okay. We have a little bit of time. I'm sorry, is there anybody else on this topic before we either take our lunch break a few minutes early or start our next topic? Andrew.
Wendy has her hand up too. I'm not sure if it's a is it?
Vestigial, Wendy? No, I mean, yes, it was vestigial. It's gone now. So Andrew.
I would love to bring a motion to increase the number of public members to 9 if possible. And the reason for that is just in line with some of the things we heard from the consumer lawyers. I think having the public involved is a really great way to ensure that they are, protected. So I would like to bring a motion for that.
All right. Is there a second?
I'll second that.
I'm sorry, there were 2. Try again. Who seconds it?
Sure, I'll second it.
Becky Sandifer seconds it. Got it. Any further discussion we need to have before we vote on Andrew's motion?
I had my hand up in case you hadn't seen it.
Yes, Wendy.
I think that there's a complete misunderstanding and misapprehension of what the public comment has been. The public comment was from consumer advocates and individuals who represent civil rights complainants, was that there needs to be oversight similar or the same as attorneys. I think trying to use this to increase oversight that would not include attorneys is disingenuous, frankly, and it completely misapprehends what the public comment was and the gravamen of what the public comment was and the specificity of each of those members of the public. On every meeting that I've been in, there hasn't been a single public comment in support of these changes. I think that speaks volumes in and of itself. They've raised particular concerns about consumer protection, and it wasn't, let's have individuals who do not have knowledge of our laws or who are not barred be governing the hen house. I think this is the fox in the hen house, and I think that's exactly what it's intended to be. And it's deeply concerning. I remain deeply concerned about those issues, and I don't feel like that is in the best interests of consumers, and for all the reasons stated here, as well as in my public comments.
Thank you, John.
Yeah, I appreciate the opportunity to raise the point about the public comment, because what's striking to me about that public comment session, and for that reason others, is it's evident that the people commenting, first of all, don't actually have any data to support what they're saying. They're listing parades of horrors about this, that, and the other thing that's going to happen, as though purely because they're lawyers, they know these things. And what they're missing about the sandbox is that that's a place to test these things and develop not just bare opinions, but data about whether these things do or don't matter. And I take those public comments largely as people who I don't believe have the consumer's interest in mind, but rather are motivated by their professional organizations to come in and try to resist this type of effort, actually to the detriment of consumers.
All right, I'm gonna jump in here and say, in the interest of keeping the debate moving, that I'd like to stay focused on Andrew's proposal. And I hear your point, John, but moving it along.
That for that reason, I support having more public members. I actually think they're more likely to safeguard and protect the interests of the public than lawyers who simply don't seem to understand that we aren't providing the public with needed legal services.
Okay, thank you. Micah.
I said earlier, I think it was the first thing I said at this meeting, I find any comment by anyone associated with the work of this committee that is derogatory or demeaning to folks who call in and are making public comment, particularly attributing those comments to organizations and calling those people uneducated. I just find that kind of personalization beyond offensive. I think it's beneath.
Well then, Micah, let's stay away from the personalization and stay focused on Andrew's motion, please. Do you want to speak to Andrew's motion?
No.
Okay, Ms. Scutero. You're on mute.
Can you hear me now?
Yes.
As a person who has I don't have my personalization is that my focus on being on this committee is as a consumer. So, you know, I've gone through being a single parent that was low income and gone through college and gone through the process and had to use the legal system. So I agree with Andrew, and I would like to have this vote. And for this session, is a little bit more contentious than normally we have. And I hope that we can not have that in the future. That's what I'm going to say. Thank you.
Kevin?
Okay, as to the comment that the consumers are going to be in a better position, there's this belief the consumers will be in a better position to regulate, oversee what's going on by this regulatory entity. I'll ask, where's the data that supports that finding? I don't think there is any data that supports that finding. And I just want to point out that the person who wanted to have the attorney added, the 6 attorney members, was his understanding, was one of our liaisons from the Supreme Court. So I don't see how you can take the public comment that was stated earlier and do that to lead to this logical conclusion that we need to increase the number of consumer or public members on this entity, the regulatory entity, which is why I'm going to vote no. Thank you.
Okay, Crispin, on the subject of Andrew's motion. You're on mute.
Sorry. I'd just say the experience from the UK is that most regulators in most professions have a majority of non-professional people, and I think the UK regulatory system is recognised around the world. I'm not a lawyer. I've never been a lawyer. I've regulated lawyers. I've regulated dentists. I'm not a dentist either, and I'd quite like to think that lots of members of the public can bring all sorts of skills to effective regulation and oversight.
All right, thank you. I would like to have Mimi call the motion and let's vote.
Okay, the motion is to change the number of public members in Resolution 5 from 7 to 9, to increase it to 9. Marta Alkenbrock, Andrew Ruda,
Yes.
Judge Irma Asbury, Marion Baldwin,
No.
Judge Wendy Chang,
No.
David Engstrom,
No.
Tom Green,
No.
Dan Grunfeld, Eric Helland,
Yes.
Kathy Huang, Micah Star Liberty,
No.
John Lund,
Yes.
Kevin Moore,
Oh.
Wendy Mussel.
I'm sorry, I didn't hear the last vote.
I believe Kevin said no.
Okay.
No.
Wendy Mussel,
No.
Crispin Passmore,
Yes.
Toby Rothschild, Becky Sandifer,
Yes.
Jim Sandman,
Yes.
Patricia Scutiero,
Yes.
Sacha Steinberger.
No.
Okay, hold on. 1, 2, 4, 5, 6, 7. I have 7 yeses and 8 nos.
So the motion fails.
Yes.
All right. So team, we've had some things that were contentious this morning, but we have made some progress toward making some decisions that we as a group needed to make. There are many, many more decisions to come starting later this afternoon. We will take our lunch break now and return at 1 o'clock with the anticipation we will start at the end of the agenda with, I think it's point I at 1 o'clock to resume. All right. Have a great lunch, everybody, and we'll see you soon. Bye.
I believe Kevin is at a faculty meeting right now from 1 to 2.
Oh.
And so I would be glad to carry on my own, but I would just note that, you know, Kevin is some of our really extraordinary resident legal ethics expertise. And so it might make sense to postpone that. I hate to throw a monkey wrench into things, but it might make sense to postpone that to later in the agenda.
Okay. The problem is that Kevin is integral to half of our presentations on the local rules. He worked with 2 of the 4 local rules teams. And I do want to make sure that we get to this item before 2 o'clock. And it sounds like he's due back at 1:30?
I think he said he's due back at 2. I think it's an hour-long meeting.
Yeah. Well, then we're going to miss him one way or the other. But why don't we start with our 4 presentations on the lawyer rules? And I said at the outset, I was really impressed at how much careful work had gone into these. And the presentations and discussions are actually going to have to be even shorter than I had originally allotted for, because our morning discussion ran longer than expected. But do we have Toby and Judge Chang able to start us on the lawyer advertising and solicitation discussion? I know that you weren't expecting to come up right now, but if that works for you and we could do that, it would be great.
I think
Wendy,
I
do you
saw
want to start?
Toby.
Yes, you're both here.
We're
Okay.
here.
Toby,
Wendy, do you
so-
want to start?
No, you start.
Oh, no, you go ahead. I need to find it. I just got
Okay,
it.
well, I can't then. So we were charged with taking a look at the scope of assignment on whether or not we should adjust the advertising rules to conform with the model rules and or any other recommendation for potential reform. And I guess starting with whether or not we thought it was something that would be a good idea. And so at the very, very least, when the ABA went through their advertising rule changes, the Rules Revision Commission was still in session, but it was moving slightly, I would say probably 3 months faster than the ABA was. And so what ultimately occurred was the rules that ultimately got passed, which are our current advertising rules, were passed before the ABA ultimately made their changes. So there are still some slight variations between the current California rules and the ABA model rule advertising. The other thing that we were to look at is whether or not we wanted to expand a reformed process in the advertising rules to conform to what the Association of Professional Lawyers had recommended, which was a very, very sharply narrowed, not so much narrowed, but they just pulled it back to a single, thou shalt not lie, basically. And then they added a whole bunch of explanation for what that meant. And ultimately, Toby and I looked through all of this, and we do think at the very least, we should be conforming our rules to the model rules as they are currently stated, because the model rules tend to be, they're a little bit more, I think they're more refined as they amended it, and they also are better at adjusting to technology and the modern technology. And so, and it won't, at the end of the day, I don't think it's going to cause a tremendous amount of controversy. It's not going to make a huge change in what our current structure is now. it's just going to make it a little bit easier, and it will also make it a little bit more uniform. So when you have attorneys who are practicing across state lines, it might make it easier for them to kind of understand and follow the rules. Because right now, the advertising rules all across the country are slightly different in each of the states, and especially for the lawyers who move or the law firms who have they have offices in more than one state, it gets a little bit tricky. And so that's where we are. The other thing we would do, though, is to take a look at states that ended up adopting the new model rules on advertising, take a look at if they modified any of the model rule language, and to see if we felt like those new approaches were better, or if we just thought it was better, and that we would, if they were, we would recommend it. But we haven't done that yet. But that's just the approach that we are recommending. So Toby, did I miss something?
I think you got it right on. I think we know of at least 6 or 8 states that have adopted the model rules with modifications, and there are new ones happening every day. I think New York has ones pending that haven't been formalized yet, adopted by the court, but they're in the works, and other states. And we need to take a look at the universe out there of those that are using the model rules as the base and modifying them, and then figuring out what the best way to go forward is.
Okay, so that's very helpful, as was your extensive memo. What I understand you to be saying is that the half a dozen changes that the ABA rule would make over what our current California rules are, and these are all listed at the top of page 4 in your memo, including, for example, defining solicitation in a way that is much narrower than the current definition of solicitation in California, and no longer requiring an address for an attorney or law firm on employee advertisement, or that it would even be labeled specifically as, I'm sorry, I said employee advertisement, I meant attorney advertisement, or labeling it as attorney advertisement. There's a change here that the prohibition concerning real-time electronic contact would be deleted. So there are some substantive proposals that you're in saying you think we should consider recommending the ABA rule as a starting point. You've got a series of substantive proposals that you are inclined to recommend to our group. Do I understand that correctly?
Yes.
Okay.
Yeah, that's the direction we're looking.
Okay. For the person scrolling through, you're about 1 page too far. It's at the top of page 4. There we go. Bingo. That's the language I was referring to, plus the footnote that you can't put on the same screen. So that was a very helpful and succinct summary of a very detailed and helpful memo. Are there reactions that folks had, recognizing this is not about a vote, but just to the extent that people had considered views you want to share about whether that's a recommendation you are excited to see or have reservations about already? I think it would be helpful if you want to share those now before we move on to the next rule. Crispin has a comment.
Thanks very much, Chair. I just refer to my written comments really and say I think we should go as far as we can in trying to open this up. Advertising is likely to be a key part of how new services and new technologies connect with consumers. It's how markets work. It's how every other professional service works. And I very much like the paper, but I would go as far as the do not lie model. I think lawyers are under enough ethical obligations to behave appropriately, and I don't think we need to constrain them with detailed rules around advertising.
Thank you. Andrew.
I would echo what Crispin said. In particular, I think one of the things that has been really advantageous to areas like personal injury and kind of workplace harm being and folks knowing that what their legal rights are has been actually an increase in advertising in that those consumer realms, and I think increasing and therefore I echo what Crispin had to say there.
Thank you, Jim.
I agree with Crispin. I think that what Utah has done in this regard is a useful model.
Thank you, Wendy.
for California, we have some very a large interest in consumer protection, and in particular regarding the ability of consumers to address where not only there's express misrepresentations, but also other types of communications which could negatively impact consumers. And I would just caution us to open this too far, and that we consider both the statutory bases that already are covered under California law, as well as ensuring that consumers are protected. The laws seem to be working that apply to attorneys. There hasn't been any particular study that demonstrates this need that at least has been provided, and I would indicate we should proceed with caution.
Thank you. Other commentators? Jim, your hand is still raised, but that may be vestigial.
Can I make a comment real quick in response
Yes,
to what
please,
everyone
Wendy.
just said?
Judge Chen.
It's okay, Wendy's fine. I think that in terms of prosecutions for advertising violations, they typically don't happen. Most of this stuff does typically, I think, resolve itself in phone calls to just, fix this and fix that. So the reason we don't have, I think, prosecutions largely is because it's all being handled on the other end. And the reality of it is, as far as I understand it, and I would ask Mary to correct me, or Toby, the vast majority of these complaints that are on advertising violations, they're from competitors. These are competitors trying to harm each other's business models. They are not really from consumers. And so, and I'm saying all of this because I was involved with the ABA changes to the advertising rules. And we went through a lot of this during that time, and we tried to really take it down and really analyze what exactly was it that we were trying to protect from, what really was the realistic harm that was happening, and we adjusted accordingly.
Okay, thank you. Are there other comments on this before we move to the next rule? Super. Let's move. So let me thank our first presenters and say that I think you accomplished exactly what I was hoping you would. You gave us all an introduction, in fact, a very thorough introduction to what are the issues that we will be considering when we get to the place that we are looking at actual proposals and making actual votes on rules that were part of our charge, as opposed to on the Sandbox part of our charge. Okay, next presentation. I lost my agenda, but it's the other one that Kevin's not on. It is Mary and John on lawyer referral services.
Great. Well, I'll be taking the lead on this for the two of us, since we seem to be paired up in everything that he and I do. So we got to play it off a little bit. Thank you, John, for being my partner in all of this. So the lawyer referral service issue, and we tried to summarize, tried to touch on, to give a good overview of this in our short memo. And thank you, staff, for your help in getting this together. There are a couple of interesting issues. A lawyer referral service is obviously an important tool in providing access for consumers to counsel. A lawyer referral service allows, consumers a way to access legal representation. And, one of the things that the research always points out is how consumers often feel that they don't know how to find lawyers. So that, that obviously elevate, and that's even with the lawyer referral services that we currently have. In California, we regulate legal referral services a little bit differently than in other states. And we have a statute in the Business and Professions Code that provides a pretty comprehensive regulation of legal referral services. And that's the Business and Professions Code 6155 and 6156. And we've included some of the key provisions there, and you'll see they're very, very detailed. So one of the issues that at least we've identified as, possibly something that we should look at as part of our charge from ADLs is whether or not to suggest any changes to that statute to the legislature. And obviously, from the perspective of how to increase access to justice and access by consumers to legal services. And we don't, we are at a very preliminary place in our own analysis of these issues. So we definitely are not intending to make any recommendations here. And this initial memo is really just intended to highlight some of the possible things that we will look at and that the committee may want to consider. So one of them would be, whether to recommend to the legislature any changes in the Business Professions Code. And that could include, for example, removing some of the restrictions that are currently in the statute, geographic restrictions, for example. The ABA has recently recommended changes to its lawyer referral service rules that allow lawyers who maybe are not physically present in a given area, but who can demonstrate an ability to serve consumers in a particular area, for example, to be included in a lawyer referral service. So that'd be an example of the kind of change that we might consider here. And we've listed the 7 kind of, potential issues that we would look at. I want to also just highlight one additional issue, which, may seem pretty specific, but it comes out of, sort of a history of events in California, which Justice Tucker is well aware of. And that is the issue of whether lawyer matching services should be regulated as lawyer referral services. So we've just addressed this in a short paragraph on page 4. In 2019, a case came out of the California appellate courts. I think Justice Tucker, you may have authored that opinion, Jackson versus Legal Match, which
I didn't author it, but I joined it. I was on
there you
the
go.
panel,
Okay.
but not the author.
All right. Which the opinion found that Legal Match, which was an online lawyer matching service, was a legal referral service subject to regulation under the Business Professions Code. And for those of us, who've, certainly who deal with the ethical issues around advertising and related issues, the issue of whether a matching service, was a legal referral service and was subject to not only those specific rules, but also more generally limitations in the professional rules around fee sharing and referrals and related rules. That's been something that people have looked at for a long time, and there are ethics opinions from all over the country that come out kind of different ways on that issue. In my understanding, Jackson versus Legal Match was the first statement in California that a matching service was something that had to be regulated. And so this became an issue. I just know that attorneys who had participated in Legal Match over the years, were subject to investigation by the state bar. I don't think anyone was actually disciplined, but then the state bar initiated litigation against Legal Match after the Jackson case came out, and you guys have all read about it in the newspapers. Last September, Legal Match became a certified lawyer referral service. Only point all that out to just suggest that there's a history now of, in California of regulation now as of, 2019 or 2020 of lawyer matching services. And I think it's certainly something that this committee and ADL's identified this as one of the things that this working group should look at is should lawyer matching services be regulated as lawyer referral services. So that's one of our issues on that list of 7, things that we're going to look at. So I guess at this preliminary point, I'd certainly be interested, I'm sure John would, in any thoughts people have. We're interested in everybody's input. If people have other specific items they would like us to look at or put on the list for further consideration as we roll this forward, we're certainly open to all suggestions.
Toby. And then Judge Chang.
I just wanted to point out California rules in some ways are beyond, more expansive than other states in the fact that they allow for-profit referral services, which many states don't, and that they allow pure online matching without a human intervention, which is a new addition in California that, again, is not common among the states. And I think both of those show that we've made changes to make it more helpful to consumers, and we need to be careful not to go too far.
Thank you, Judge Chang. If your hand is still raised.
It is. So I just wanted to just say, in my opinion, this is a huge access issue. So many times, I can't tell you how many times a day, I have litigants staring at me going, well, how do I find a lawyer for that? Where can I get some help? Who can help me? And I'm an unlimited jurisdiction court. I am not small claims. And so there's no help out there for people who appear in my court. And so as broad as we can get with this rule while still protecting people is where I would like to see us go, because this is a huge issue.
Thank you. Crispin.
Thank you very much. Again, I refer to my written note on the comments. I agree with Judge Chang. We should go as broad as we possibly can. We should recognise that there are risks around referral. Wherever there's fees involved, there's risks. But attorneys are well used to handling those risks. We should stick to what we're good at, which is regulating attorneys rather than regulating referral and similar sorts of services. And by putting clear ethical obligations on lawyers, we can manage the risks that exist. And they should only take clients through referral that they're happy that it's the right thing to do. As long as lawyers are required to act in the best interest of their client, then it doesn't really matter how they get to their client, as long as they're referred ethically.
Oh, thank you. Other comments? Okay. Then I think we should probably at this point move to scope topics. And I'm going to ask our scope co-chairs, would you like to move to agenda item I, even though we don't have Kevin here? Or would you like to do the application, which we hadn't intended to get to until after Arizona? I didn't anticipate that I didn't think about the fact that he would be missing during the point when we finally got to so many of the things we need him for.
Tom, do you have a thought on that? Do we have Tom? Well, if we don't have Tom and we don't have Kevin, maybe we could move to the application then.
Okay.
So you have seen before you a number of drafts of this application, and what the scope subcommittee is asking of you today is to approve this as a draft. And I want to put that in some context. So obviously, this application is about information that would be asked on the front end of an entity to figure out whether it could enter whatever sandbox might someday exist. There's a whole set of policy decisions that are not made, and many of them are called out in the application. So what fields of law or kinds of problems can you work on? We haven't established that, for example. We're going to talk later about confidentiality and privacy and the use of data. And once we establish that will determine some things about the application. The other thing that we haven't, that no group of this body has discussed yet is, once we get the information, what will we do with it, right? So how will different pieces of it be evaluated? So that's all still at play. So those are really important questions, and we absolutely will spend, I think, a lot of time talking about them. But today, I think our goal is to get from the broader group your sense of whether this is the right stuff to be asking about. And with that, I think I will just, you've all had a chance to look at this several times. I will just hand it back to, I'm happy to run the conversation, but otherwise I will just hand it back to Justice Duper.
Okay. So I'm happy to run the conversation also and to call on people as they wish to make comments on the application that's been offered. I guess I should ask, Becky, are you asking for a vote on the application today, or are you making a motion of any sort, or are you just looking for discussion with the idea to do that later?
So the application comes out of the scope group with a unanimous recommendation that this be the draft application. And so if we want to start there, we can. But if folks who feel like there's input that they want to give before we do that, it's up to you, Justice Duper.
Okay. I am not seeing hands right now. I know there were comments on the application from Wendy, but I got a note from her saying she had a court appearance she had to run to. So,
and you know, I thought that her comments were very important. They were to a large extent about policy decisions that have not been made yet. So they're not reflected in the application and they're not meant to be.
Okay. So are there other issues about the application that people wish to discuss, or concerns about the application they wish to air, or, you know, changes you'd like to suggest to the draft as it currently stands? Mary has a comment.
It's more of a question. On the first page, the applicant information, you've got 1.1 applicant entity, legal name, all that. Then it goes down and says applicant is applying as a, and there's a couple of, you know, there's 5 different choice boxes to click. Traditional law firm, large non-law firm. So is it intended that this section applicant is applying as a colon? Are these options intended to encompass every possible applicant who might apply? So every applicant, every person, every entity or person who's submitting application will check one of these boxes.
I think the idea is that every applicant, every entity will check one of some set of boxes. And this is a set of boxes that reflects the state of the conversation now, but the scope conversation will determine what those boxes are.
Okay. All right, then that's fine. It's looking at this list, to me, it didn't jump out as that these categories were necessarily all sort of important or of equal importance in evaluating an application, or that they were comprehensive in terms of identifying all of the different entity forms that we might regard as relevant to an application. But I don't have specific changes to suggest. I just wanted to make sure I understood how it worked.
Would it at this stage of the conversation, would it kind of answer your issue, which I think is an important one, to say type of organization, for example?
Well, type of organization is up above. And, you know, that, you know, and that set of criteria, that set of choices up above under type of organization seems, you know, again, I'm not a corporate lawyer. It seemed like a reasonable list of choices. I'm talking about the one just below. Applicant is applying as a.
This might be an issue where iteration, as Becky suggested, will change things. My guess is that this list comes from the Arizona application and corresponds to categories that are defined in the Arizona application and given different fees accordingly. $2,000 for an application from a local nonprofit, $12,000 for an application from an entity that has, you know, offices in different countries. And so we might end up with a different list here from the ones that have boxes when we get around to saying, look, are we going to sort people into classes and charge them different fees? And if so, what are the classes? And then that set of options would be the set of options that would be substituted in here. Does that sound right, Becky?
Yes.
Briefly on that, we have a small team looking at whether we could charge different fees for different kinds of folks. So this maps to it.
Okay, Micah.
What is meant by international applicant?
Well, I can tell you that Arizona has a definition of it that I can't quote verbatim, but I did read last night, and it's basically a law firm that has offices there. So for example, Morrison & Foerster is a San Francisco-based law firm, but they have offices in Japan and London and various other places. So I think they would have to apply as an international applicant. But a more precise answer to your question depends on, the iterative process of us deciding if we're going with these categories and how do we choose to define them, because obviously we don't necessarily adopt lock, stock, and barrel what Arizona did.
Sure, I guess I'm just wondering if the intention was to adopt the Arizona definition.
From what Becky says, it sounds like the intention is to be iterative and to consider revisiting the specific categories.
Yes, because they await other decisions.
It might be useful, Becky, for you to talk to the group a little bit about something that's both in the application and in the separate memo regarding authorized persons, especially because we're going to be hearing from Arizona soon on a related subject.
So Tom, if Tom is there, he's disappeared, has actually taken the lead on drafting the definition of an authorized person.
There
and
he
then an
is.
authorized person becomes the person who gives you the key information that involves the disclosures about different kinds of past conduct and so forth. Tom?
Yeah, it looks like my audio works, but oh, now I have video. So basically, we have taken the authorized person definition from Arizona and added a couple of things. And so what we've done is authorized person for purposes of this application are those persons who will be required to submit the disclosures that you see appearing later in the application, many of which you wrote, Micah. And we've included two basic concepts from our friends in Arizona. One is you're either an owner or have an ownership interest of 10% or more, or you possess the legal right to exercise control. I'm thinking that that's like a CEO kind of person or some version of that. Or, and this is a term that is borrowed from Arizona, and we as a group have not decided that this makes sense, but if we do make that decision, this would speak to that, and that's a compliance lawyer in both Arizona and the United Kingdom, and as I understand in Australia, they have somebody who is a head of practice or an Arizona compliance attorney. In an ABS situation, that person assures that the attorneys working within the organization follow the local legal rules, and the compliance attorney is responsible for making sure that happens. We have added a bit, which appears a little further down, maybe if you're the scrolling person. We have added in the definition, decision-making authority, which is a piece of language that appears in authorized person. This last little bit, which we've left a little bit open, which is somebody is a direct supervisor of people that are providing direct services. So we're saying that is a person who supervises 5 or more people. So there's still a little bit of conversation within our subcommittee in terms of whether it should be 5 or 6 or 25 or whatever. But that's the basic authorized person thing. Is that semi-responsive?
Micah, is that semi-responsive? You're on
right.
mute, but I see the thumbs up. Crispin, on the application.
Thank you, Chair. Just on the point Tom was making there, I would just caution against getting too deep into an organisation. And if you applied that sort of decision making into a law firm that was a large law firm, you'd be authorizing the managers of hundreds of people in firms that are supervising in that sort of scale. And I think if you get the structure right, with the entity being authorized and people with significant control, chief exec, perhaps some of the exec team that are in the direct line management of the service, I don't think you've got a compliance lawyer who's responsible for the systems and has board level access. I don't think you need to get into authorizing the individual managers of people doing the work. I don't even think it's effective regulation. I think it's much more effective to hold to account senior people for what happens in their organization than it is to try and pin it onto really quite junior managers with 5, 7, 25 people working for them. So I would just caution against that. I think you might find you're authorizing hundreds of people who really have very limited control within an organization.
Other comments on that point or otherwise? So to Becky and Tom, I'm not hearing a lot of discussion or concern or challenges. We did just get one very specific and I think important, helpful point from Crispin, but it sounds like it's on an issue that Tom said Scope was still thinking about, whether it should be 5 or some much larger number. So would you like some further direction from the group, or would you like to carry on knowing that this was the reaction you got on the application at today's meeting?
So given the reaction we got on the application at today's meeting, I would propose, I would move, I guess, that the group consider this as the current draft application pending a set of policy decisions, and that it's the thing that we work on from here on out. It's our starting point.
Okay, so
if you
you're
want to put that in lawyer language, that's great, but that's what
you're asking us to authorize this as the basic approach we agree on, with revisions to be addressed going forward as we make other policy decisions. Is there a, go ahead, Tom.
I would second that. So I'm not the chair, I could second that.
All right, is there further discussion? Micah has some discussion.
Yeah, I would feel a lot more comfortable if we called it something like a working draft. It's, the policy decisions are, to me, the most important part of it. And so today has been focused a lot on, structure right now. And then I feel like a lot of things are TBD, which is an okay way to do things. But I don't want us to, I couldn't vote to adopt this as anything other than a draft that we will continue to work on pending decisions that we're going to make about policy and definitions.
So Becky and Tom, would you accept that as a friendly amendment?
I'm good with it. Becky, what do you think?
Sure.
Okay, thank you. John, you're on mute.
I actually agree with Micah about this, in the sense of, I think it's really the policy decisions that, are the most important part of this. And I guess the question I have that relates to this is for Becky and Tom, which is, we're structuring this through an application. How is this going to look in our ultimate submission to the board? Is it going to be, we recommend a sandbox regulator and this is the recommended application to be used, or is it going to look like a set of policy decisions about, who would be allowed to be admitted into the sandbox?
I can't speak for Tom, but speaking for myself, I would say in our work with the scope group, because the policy decisions are so meaty and they're so central to thinking about the design of the sandbox, but also these kind of administrative parts are also really central, it seemed to be more efficient to separate them and pursue them in parallel. And so my recommendation, but this group gets to decide what its report says, would be that it say, here's what we recommend and here's how we think it should work. But getting to that point requires us to make, at least in my mind, a set of discrete decisions about different pieces of that system.
Yeah, and I think I'm just going to echo Becky here, but from my perspective, sort of laying out what an application form would look like helps people focus on the really important aspects of this. We do have a number of very specific, very meaty decisions to make in our subcommittee, and those will be reflected in the ultimate draft of this application form. But I think this is helpful, would be helpful across the board, because this has to be reviewed by the bar, it has to be reviewed by the public, it has to be reviewed by the legislature. I think this is a helpful document to include in the package we submit to all the various stakeholders that need to take a look at it.
Thank you, Donna.
So I appreciate this question because I think Tom is right that sort of creating a document that reflects these policy decisions is helpful, but I think we may want to think about what the board is approving or sort of the policy decisions, right? Because none of us want the board to have to sort of go in line by line and say, yeah, we don't think the application should have the business facts number, right? So it was one of those silly things that jumped out at me, the administrivia, as we talk about, that I wouldn't put on an application, but we want the contact information of these key people and we want to have every possible source of contact information. I think it's fine for a working document and that we put out a document, but we may want to sort of, the form itself would be, the form could look like this, but we've just, in the report to the board described really the key policy decisions and or administrative decisions, which are essential components of what this application looks like.
Yeah, I think reasonable minds can differ on this. I mean, the one thing I can report to you, Donna, is that in the initial discussions about what should be in an application form and the front end of the process, people really liked Arizona versus Utah in terms of detail. So that the fact that will be demanding a fair amount of detail about what is this organization, how's it going to work, what is its business form, the background on people. I think that at a high level is kind of a big deal. So, but I think hopefully at the end of the day, there'll be a report, there'll be a bunch of attachments, and hopefully this will fall mostly on your guys as opposed to us, a crisp delineation of the policy questions that we're asking the Board of Governors to approve.
All right, so we have a motion to adopt this as a working draft subject to continuing efforts as policy decisions get made. Unless there's further comment, I think we're ready to vote on that motion. So Mimi?
Okay, Martha Alkenbrock, Andrew Arruda,
Yes.
Judge Irma Asbury, Mary Baldwin,
Yes.
Judge Wendy Chang,
Yes.
David Engstrom,
Yes.
Tom Green.
Yep.
Dan Grenfeld, Eric Helland,
Yes.
Kathy Huang, Micah Star Liberty,
Yes.
John Lund,
Yes.
Kevin Moore, Wendy Mussel, Crispin Passmore,
Yes.
Toby Rothschild,
Yes.
Becky Sandifer,
Yes.
Jim Sandman,
Yes.
Patricia Scutiero,
Yes.
Sasha Steinberger.
Yes.
Thank you.
All right, thank you. And I'm glad we were able to accomplish something with unanimous support this afternoon. I would like to move to the agenda item I, recognizing we still don't have Kevin back, but since Kevin is a participant in each of the 3 remaining agenda items, that seems helpful at this point. David, are you prepared to do that?
Absolutely. Yeah,
Good.
I can do that, Justice Tucker, for sure. So as I noted just a few minutes ago, this is something that Kevin Moore and I ran point on, and we wrote a memo that was circulated previously, but I don't think made it into this set of materials, but hopefully members remember that memo or at least have access to it if they wanted to refer to it during the discussion. Relatedly, I think I've already presented a version of this to this group. My memory is a little hazy because I think I've done it at the subcommittee level and at the whole group level. But I nonetheless will do the same rehearsal that I did previously, which is just offer a couple of orienting thoughts about how we approach this problem and what we see as the real policy puzzle to be solved here. And then I can spend some time talking, not too much time, but some time talking about what our recommendation is and how we got there. So first off, but with the orienting points, this just again retreads what I've already told you all, but the basic top line puzzle here is that confidentiality, data security, privilege, these are already regulated for some of our entrants to the sandbox. That is to say, entrants who are lawyers. They would be subject to various duties under the rules of professional responsibility. But those rules would not necessarily by default apply to others. So non-lawyer entrants to the sandbox would obviously not be subject to those rules or required to comply with them. And so that would include things like Rule 1.6 on duties of confidentiality, 1.1b on a duty of competence, which has a technological component to it, Rule 1.9 on use of information from past representations, and then Rule 1.8.2 on use of a current client's information. So those rules will apply to some entrants, not others. There's also, by the way, the CCPA, which as a result of yet another referendum is now, I think, going to be called the CCRA, the California Consumer Privacy Act. And that's another example of a set of constraints that will apply to some entrants and not others. And so the key question, I think, once we realize this is, the key question is whether we would want to level up, as we put it in the memo, as to some of these rules and therefore apply them to all entrants, whether we would want to perhaps level down, which is to say, urge the legislature and the Supreme Court to not apply those rules to all entrants. That's entirely possible. Or whether we would tolerate a certain amount of lumpiness or asymmetries within the sandbox, with some entrants being subject to these constraints and some not. So that's the first orienting point. The second orienting point was that I urged all of us, and this was at the scope level, and I think it applies to this group as well, to think in terms of the concrete situations where this will be an issue. And there are really two main ones with a third tag-along situation. So the first concrete situation where this will come up will be voluntary disclosure of information. So, and in particular then, an entity's or an entrant's attempt to commercialize data that they have based on services that they're providing. The other scenario then would be involuntary disclosure, and you can think of that in terms of hacks or cybersecurity breaches of some sort. The third tag along would be compelled disclosure. So this would be where maybe a client or a consumer is compelled to give up information about a representation or about that relates to the provision of a legal service within the sandbox, and typically in some sort of a legal proceeding. And so this is obviously the attorney-client privilege situation. So those are the three concrete situations. I think that's useful to ground our discussion, to realize that those are really the three contexts: voluntary disclosure, involuntary disclosure, and compelled disclosure. So now to the recommendation, which you see before you on the screen. The scope committee's recommendation was and is to level up as to the professional responsibility rules that are listed there. So 1.1b, 1.6, 1.8.2, 1.18, and 1.9. But not then as to the CCPA, or what will now be the CCRA. And I think what that means is two very practical things. The first is that in practical terms, and at least under current interpretations of those rules, this will prohibit all sandbox entrants from commercializing their data without first getting client or consumer consent. And I think that's important. And I think that addresses Wendy's comment and question about commercialization, which she's raised a couple of times in the proceedings to this point. And this strikes me at least as right as a policy matter. The reason to permit commercialization of data by a sandbox entrant would be perhaps if we thought that the revenue stream that could be derived from that would subsidize the provision of services that otherwise couldn't be provided. So you can imagine it as a boost that allows someone to reach groups who have a less ability to pay for legal services of some kind. But I guess my own personal view is, and this is certainly subject to discussion and debate within the group, is that whatever value that commercialization might hold in terms of subsidizing services and giving a boost to the types of services that a sandbox entrant can provide, that would be that wouldn't outweigh the confidentiality and privacy concerns that we should have about sandbox entrants using data in that way. The other practical effect, of course, of leveling up is that all sandbox entrants will have various duties with respect to safeguarding the data of their clients or of their customers from hacks, cybersecurity breaches, that sort of thing. There are a couple of reasons why I think we arrived at this recommendation. One is that I do think consistency, or maybe we think that consistency has at least some value, that avoiding a mix of obligations among sandbox entrants is a good thing. But I think the more important rationale for leveling up in this way is that I think in a really useful way, it hitches the rules that will apply to sandbox entrants to what will no doubt be an evolving body of interpretations and ethics opinions and the like, with regard to the rules that are listed there. And I think that's really important. I think a certain amount of humility is in order for all of us, because we don't really know what the digital future is going to hold in terms of commercial uses of client data. We have law firms, for instance, who are quite explicitly trying to move along some sort of a continuum from service to product. They're clearly going to be involved in those sorts of efforts, and we don't know what kinds of practices might emerge. What we do know is that when those practices do emerge, they will be addressed, I would think, by through the standard processes, and that we will get an evolving sense of what the various rules mean when applied to those practices. And so I think in a really salutary way, if we level up and say these rules apply to all entrants, we get the benefit of whatever that evolution is over time as we move into a somewhat uncertain digital future. A second reason why we arrived at this applies to the CCPA, CCRA side of things. And I think there's a really important concern. I think it's important to remember that the CCPA applies only to very large entities, and I think the interpretation of an entity's duties under that law is going to evolve over time in light of that fact that these are very large entities. And so you would worry about leveling up and extending those requirements to what may be relatively small entities within the sandbox. It could be that there are a set of quite onerous regulatory requirements there, or a set of requirements that are designed for a larger entity that we might not want to apply to smaller entities. So I think our recommendation there is to leave out the CCPA, at least as to sandboxed entrants who wouldn't normally need to comply with it. Final point on this, which is the attorney-client privilege. Here I have to make a kind of embarrassing admission, which is I'm not sure, based on a quick email exchange with Kevin before this meeting, whether we agree on what we did as a group with respect to the attorney-client privilege. And I can say quite frankly that I thought that we were recommending that the attorney-client privilege not be extended to sandbox entrants who wouldn't otherwise be cloaked by it. And I think Kevin had a different view. So I guess I would need to say then that I think that's something we should open up for conversation within this group. You can see in recommendation 2, though, that we are recommending that that whatever regulatory entity we construct to preside over the sandbox should have the ability to pierce both confidentiality and the attorney-client privilege in order to do the oversight and regulatory work that they would need to do. That's the orienting points. That's the recommendation. So I suppose I can now turn it back over to you, Justice Tucker, as chair, and we can have some conversation about it. Does that seem a reasonable way to proceed?
It does. It's going to be a very short conversation for right now because we're about to break for 2 minutes and then hear from Justice Timmons. But Jim Sandman had mostly a question, I think, seeking clarity. Do you want the floor, Jim? You're on mute.
Yes, my question was whether this list of rules that would apply is exclusive. Is there any implication here that if a rule is not on the list, it doesn't apply? Or is the decision about the applicability of other rules going to be made on a case-by-case in the context, case-by-case basis in the context of particular applications?
So I'm going to suggest that there's a third answer to that question, which I think is perhaps the right one, which is we will still as a group decide whether there are other rules that should likewise be leveled up. In the interest of addressing confidentiality of client data and the attorney-client privilege, we were grateful for the Scope Committee and David and Kevin in particular leading the charge on this one specific issue area.
Got it. So this is a first cut.
This is a first cut. I think it's meant to be, except for, as David points out, recommendation 1 doesn't address attorney-client privilege yet. I think it's meant to be exhaustive or all-encompassing on the specific issue of confidentiality and privilege, but it's not meant to say that some completely unrelated rule either can't be waived or needs to apply to non-lawyers in the sandbox or anything else like that. It's just a discrete first step.
I'm fine with that. I just think that should be clear on the record so that the public knows what we've decided and what we haven't.
Okay, good. Yeah.
And I think I can say here, speaking for the Scope Subcommittee, or at least as to Kevin and me, that we tried to be comprehensive in identifying the rules that had those confidentiality or even sort of more broadly speaking data privacy implications. We think we capture them all, but we don't want to leave the impression that this recommendation implies that others wouldn't, that other rules are somehow not part of this. I think the more general default rule should be that lawyers who are operating within the sandbox are governed by the rules of professional responsibility, and non-lawyers within the sandbox are not, unless we say so. But I think that's a general default rule. That's not necessarily an implication from any particular utterance of us as recommenders of a sandbox design.
Thank you.
And I will say, from having attended the Scope meeting, I thought what we had agreed was that the attorney-client privilege should be included in the list of things that was going to be leveled up, so that we would be asking the legislature or recommending to the legislature that they change the rules on attorney-client privilege to reach not just attorneys, but also sandbox entrants, regardless of whether they were attorneys, to the extent they were providing legal services in the sandbox. I don't know if others' recollections are the same, and it's not so important that we come down there, but that was my recollection of what we had done. Micah, you might have the last word before we take our break. Go ahead.
I actually have a couple of questions, so I'm happy to wait until afterwards.
Why don't you pose them and we'll put off answering them until afterwards.
Okay. The data issue, if I understood David, you correctly, you were saying you analyze data in 3 different categories. One is kind of the mining and selling of data. Another sounded like an unintentional breach. And then the last was legal compulsion for the data. Oh, my screen just reoriented itself. So I was trying to look at David, but that's all right. So are you saying that there is not a prohibition on the selling of data on entities that otherwise don't operate under the confines of the CCPA. Is that your recommendation?
Do you want to answer that, David? Can you quickly, or shall we just say, we'll hold on to that thought until 3 o'clock?
If I interpreted the question right, and forgive me if I did not, but if I'm interpreting the question right, then I think that if we hitch the sandbox to all of these rules, and that's what leveling up means, that will effectively operate as a prohibition on commercialization without consent from the client.
But will it specifically operate as a prohibition? Or you're saying kind of like a rising tide raises all boats type of?
So we rejected an explicit prohibition in that regard. And the reason is that we could imagine 5 years down the pike that there is a practice of law firms commercializing data, but doing so in a way that is fully anonymized. And I realize that's a debate among data privacy experts. The concept of differential privacy and just how effective it is, it's important. You could imagine 5 years down the road that there would be practices of commercialization that would pass muster under those rules, precisely because there's sufficient anonymization that there isn't a breach of confidentiality. And so I think that points up the virtue, at least in my view, of hitching the sandbox rules to those evolving bodies of rules. I think that's the best way to do it. And again, that comes back to this value of humility, which is we're not sure where our legal system is going to go and where those legal ethical constraints are going to go.
Right.
And with that, I'm sorry, Micah, we'll pick up on the rest of your questions when we come back, but I'm going to interrupt and ask, do we have our guest speaker electronically present yet?
Yes, we do. She's here with us.
Super. Then I'm going to ask Professor Sandifer to introduce, please, our guest speaker.
Give me one second.
Justice Tucker.
I do see her there.
There
Okay,
she is.
There I am. Hi,
Welcome.
It's my privilege to introduce Vice Chief Justice Ann Timmer, who joined the Arizona Supreme Court in 2012. Before that, Justice Timmer was a judge on the Arizona Court of Appeals from 2000 to 2012, and she served 3 years as chief judge. Among many other things, she notably chaired the court's legal services task force, which recommended rules that were ultimately adopted by the Supreme Court that created a new tier of legal service provider and also eliminate Rule 5.4. She currently chairs the court's Attorney Regulation Advisory Committee and is a member of the National Conference of Bar Examiners Board of Trustees, the Board of Trustees of the Appellate Judges Education Institute, and she's also been elected to the American Law Institute. Most recently, Justice Timmer has been named Vice Chair of the ABA's Center for Innovation Governing Council. She earned her bachelor's degree from the University of Arizona and her JD from Arizona State University, yay, Law School, magna cum laude, and also holds a master's in judicial studies from Duke University School of Law. Welcome, Justice Timmer.
Well, thank you. I'm so pleased to be here. And I'm looking around the names. I see Becky. Thanks for the nice introduction. I know about half of you, which is wonderful. So it's wonderful to see all you. Well, my understanding of what you want to hear from me today is to go over what Arizona has done and spend about 45 minutes in there and then just really answer questions. Is that, if that's not accurate, speak up and let me know, or start waving your hands if I'm telling you things that you already know. And I'm sure I'm not telling you anything particularly new. I'd had a PowerPoint, but I think I'm just gonna not go with it because it's just too much going on for me in the screen. Unless you all miss PowerPoints. So in Arizona, what drove our changes? Well, I'm going to be very brief on this because I'm sure it's the same thing that's driving the changes that you all are discussing now and that other states are embracing. First and foremost, of course, it's closing the access in civil justice, the gap to civil legal justice gap. But I think it's important to also consider that
as regulators, we're examining whether the ethical rules are really serving the public interest. So when we put our regulatory hat on, my court was really looking at it with that mindset. We had been visited by attorneys, some solo practitioners and small firm practitioners back around 2012 when I first joined the court, who were complaining then that business is tough. And there had been a lot of infringement on the traditional bread and butter that these folks have been practicing in, the writing the wills, the doing the articles of incorporation by the legal tech world, and able to really take over that market with do-it-yourself forms. And so they were getting continuously squeezed in their clientele. It's been a difficult road to hoe. Well, why should we all care, other than the fact that we like lawyers, of course, is that that's really the backbone of our civil legal justice system in America, as far as where regular people go to get legal advice. That's who they go to. So we all have a considerable interest in ensuring that the solos and the general practitioners in the small towns and the counties and such really can thrive, because without them, there are going to be fewer and fewer places for regular folks to go and get legal assistance. So that was, when we put our regulatory hats on, that's what the court was looking at of what's in the ERs, what is necessary really to serve the public, and what might be restraining lawyers from engaging in the kind of innovation which will ensure that they're able to thrive and move on in this more modern world, tech-driven world. I won't quote you some of the facts and figures, but that show, of course, that solos and small firm practitioners are struggling, and that more and more big law firms and even medium-sized law firms are competing for the corporate dollar, entity dollar, more than just regular people. Another thing that we kept in mind was the ethical rules preamble, paragraph 12, says in the model rules that the profession has the responsibility to assure that its regulations are conceived in the public interest and not in furtherance of parochial or self-interested concerns of the bar. So that's something that I think that anybody needs to bear in mind. It is our responsibility as a self-regulated industry to ensure what we're doing is serving the public interest. So why didn't we go with a sandbox? I know that you all are discussing, I just caught a little bit of it, discussing going with the sandbox. Utah has gone with the sandbox approach, and other states are also doing that. And Arizona, as you know, did not go with the sandbox approach. Why not? For a few reasons. First, we are practiced at regulating entities and have a fairly well-established certification and licensing division in place at the court. Through the time that I've been in the court, after the issuance of the North Carolina dental case, more and more of what was traditionally at the state bar has been moved over more directly under the auspices of court control. So things like our ethics committees and things like that issue ethics opinions, that's now under the court. The court is the one that our licensing division licenses fiduciaries, court reporters, court interpreters, they're the firms that they practice in. For some reason that I've never been able to get to the bottom of, we license defensive driving schools in the state. We also have about half of the juvenile detention centers are under our umbrella as well. So we are used to regulating entities and have that structure in place. So that's one reason we moved more in terms of, could we construct a regulatory structure for licensing entities that are comprised of lawyers and non-lawyers in a partnership mode. Also, a big difference is in the sandbox scenarios, and I'm most familiar with Utah more than any others. In those scenarios, they're permitting non-lawyers or non-licensees to practice law. Arizona does not. So the scheme that we set up is still only lawyers or others who are licensed to provide legal services can practice law. That's it. So you're not going to have a tech firm or anyone else having be able to practice law through someone other than a lawyer. So that was a key difference for us. Third is frankly just practical cost. It's expensive to administer when we looked at it. A true sandbox approach for what we thought was going to happen, which has happened, which is more lawyers partnering with non-lawyers, but still the lawyers provide the legal services. A lot of the reporting and data gathering, those kinds of things, what we thought that's going to be difficult to sustain. The more entities that enter the program, the more you're monitoring, collecting data, trying to administer that. And we thought we were comfortable with the scheme that we were able to set up and didn't really want to have to try to take that burden on. So didn't think it'd be long-term. Also, the fact that we'd talked to our governor's office. Actually, our governor's office is very, very big on deregulation. We're not deregulating, but they are. They've been deregulating all kinds of things. So we're talking to them to try to get some advice. And they said, you know, once you let up on the reins on some things, try not to be tempted to over-regulate something, because that will be a disincentive to enter the market. So we were looking at that as well, and not wanting a lot of the constant reporting requirements on what was at least a traditional practice of law with just a few twists. So that was another reason that we went through that. Also, this program that we have is meant to be self-sustaining, so it's not dependent on grants or anything like that, because the fees and such, as we can discuss, will sustain or hopefully sustain the program. However, that said, we are still considering, now that we're underway with this system, a mini sandbox, if you will. I don't know what you would call that, maybe a sand bucket that's going to be much smaller in scope, most likely. It would be truly only looking at things in a sandbox that didn't contemplate lawyers practicing law. So if you had truly like a tech firm, I keep picking on them, if you have a tech firm that they were going to offer legal services, then that would be something that we would look at more in a sandbox and be a little bit more circumspect about it, and want that data analysis and such to see if we could, to ensure that we could regulate something like that safely for the public. So that's where we are and why we didn't like to go with the sandbox, at least in the first place. So what did we do? We looked at modifying ER 5.4, twisting it, doing all kinds of things. And eventually we came to the conclusion it simply was an unnecessary rule that is constraining lawyers and really serves no purpose as far as furthering the public interest, or more specifically, protecting the public. Why is that? At least from our research and the reports that we've gotten from academics and such, that ER seemed to be conceived in the mid to late, I think, 1920s, more as out of concern that lawyers had that corporations, more specifically banks, would employ lawyers and compete with traditional law firms. So it really was a preservation ended type rule, and not one that was at least born with thinking this is needed to protect the public as much as it was protecting the lawyer's business. Now, through the years, it's morphed into having people understand it to be something that protects lawyer independence, client confidentiality, and addresses conflicts of interest to ensure that those don't occur. Those are certainly all things that are necessary to further the public interest, protect the public. But we have other ERs that address all of those things. And so 5.4 is not necessary to further any of those objectives when we have other ERs that are even more specific to those concerns. So as part of the decision to eliminate ER 5.4, we also looked at the other ERs and strengthened those, actually added a little bit more to it, in light of the fact that you'd have lawyers and non-lawyers be able to share fees. So for example, we amended ER 1.6 to require that a lawyer make reasonable efforts to prevent inadvertent or unauthorized disclosure of confidential information about a client, even if the services the firm provides to the client are purely non-legal. We amended ER 1.8 to add a subsection M, which states that when lawyers refer clients for non-legal services provided either by the lawyer or non-lawyers in the firm, or refer clients to a separate entity in which the lawyer has a financial interest, they must comply with ERs 1.7 and 1.8A. And finally, we added just another example, amended ER 1.10 conflicts to include non-lawyers, and was added to the rules text as subsection F, which provides that a conflict is imputed to the entire firm if the lawyer or non-lawyer owns all or part of an opposing party, to make sure we couldn't get in issues there. So what are the consequences of the elimination of ER 5.4? Well, there are two. One, and this is one that people really haven't focused too much on, although I think they're starting to, that now lawyers may just simply share fees with non-lawyers, and that includes with investors and lenders. So as long as the other ERs are complied with. So if you want to fund a personal injury suit, a class action suit, rather than deal with maybe some of the, I don't know how litigation funding works in the weeds, but I'm told it's a fairly high percentage rate and such. So firms that want to front the costs, get the loans, now the lender could have an interest in the outcome that could be taking some of the risk with the lawyer and such. So that's there's an ethics opinion that was just issued by our ethics committee and approved by the court with one or two changes that came out last month that addresses that if you're in that situation, what are the ethical considerations that the lawyer has to abide by or consider when you're going to enter into some type of arrangement with a lender or an investor in a particular lawsuit. So you're not partnering for your whole firm ventures, it's just with a particular lawsuit or concern or what have you. So that's one. The second consequence, of course, or that lawyers and non-lawyers can partner now if they wish into a new entity. And we're calling those alternative business structure, which I think is the typical term used nationwide for these things, or ABSs. Of course, what we're hoping will happen with that is that it will permit innovation, but allow us to, as I say, sustain the program for years to come, relying solely on the fees that are generated by the ABSs. So unlike with law firms, the court only regulates lawyers, not law firms. But unlike that situation with an ABS is going to have to submit itself to the court's jurisdiction through a licensing process that it's administered by our Administrative Office of the Court's Certification and Licensing Division. So where we put detailed regulation of all of this is in our Code of Judicial Administration, which is AJC 7-210, which I believe we might have given you a copy of, I think. The reason we put it there instead of our regular court rules is because rules go through a whole year cycle process of comment and adoption and such and does not allow for nimble changes. Our Code of Judicial Administration does allow for that kind of change. So as this is such a new program, a new set of regulations that inevitably we'll find things that we've either forgotten or need to change or we have to address. And so this allows us to be more nimble with making those kinds of changes. I don't know if California has any kind of code versus rule scenario, but whatever allows you to make quick changes, I suggest you put something there so that the things inevitably will come up you hadn't thought of. So how do you become an ABS? There's an application process. It requires information about the regulatory structure, the ownership, the good standing, and the satisfaction of the ABS's listed objectives that we have in our code. So the information, I mean, it's no surprise, it's asking for who will be an owner or a manager of the ABS, or have an economic interest, which is a defined term, I think it's like 10%, in an ABS. There has to be, we want to know things of note. No disbarred attorneys may be authorized persons or have an economic interest in the ABS. There has to be, we're looking at, of course, at a prior loss of a professional license, because that would be a red flag. Looking for anything that suggests that past of fraud, material misrepresentation, omissions, dishonesty, or corruption that would be a bar to licensure. We're looking at, we're asking and looking at violations of rules or orders of other regulatory bodies, Criminal histories can be a bar to licensure depending on what it's based on. And it's essentially asking for the same types of information you would want to know that might prevent a lawyer from passing character and fitness. I look at this more as character and fitness for the organization itself. A key to our application process and licensure is that you must have what we call a compliance lawyer. The compliance lawyer is a designated person from the Arizona, who's admitted to the Arizona bar, and it has to be somebody with some experience, not someone that just graduated from law school in the last year or so that you can hook in, but somebody truly with some experience that is responsible ethically and for the firm to ensure that the structures and policies are set up in the firm, and then later, if they're licensed, that they're abided by, to ensure that the lawyers work independently, ethically, they have conflicts schemes set up, that kind of thing. So that it's that single compliance lawyer who is responsible for ensuring and reporting that once a year, that all of that is in place and maintained. After the application is filled out, it goes to an ABS committee, which is made up of folks from the public, lawyers, and others. In Arizona, I don't know about California, we have public members on every committee in the court, everything. So we probably have about 2,500, for us is a lot, civil volunteer, non-lawyer volunteers that work within the court system. So they're made up on this committee as well. It's currently chaired by our former Chief Justice, Scott Bales, who's now retired, but some of you might know at least. So they look at the application, and their decision is controlled by specifically listed factors, including achieving the listed regulatory objectives that we have. And the regulatory objectives are protecting and promoting the public interest, promoting the access to legal services, advancing the administration of justice and the rule of law, encouraging an independent, strong, diverse, and effective legal profession, and promoting and maintaining adherence to professional principles. So they're looking to see, will they be fulfilling those objectives or any or all of those objectives? And they're also looking at whether the structure ensures that an applicant has an adequate governance structure and policies in place to address ethical considerations that govern the practice of law. So the committee shall recommend denial of an ABS application for a number of reasons that we've just had as line in the sands, including if any of the authorized person or people that have an economic interest in the entity has made material misrepresentations or omissions in the application, felony convictions, convictions of a misdemeanor involving legal services. So after the committee recommends approval of the application, and I should say too, that the staff in certification of licensing does the requisite background checks, and again, essentially like a character and fitness, but for an entity and of the individuals who have the ownership interest in the entity. Then if it's approved, it goes up to the Supreme Court. So all 7 of us meet once a month and get a presentation on each application and a recommendation. We read the recommendation and discuss it. Is this something that we feel confident that can practice law and while the public is protected? And it's important to know, again, that the non-lawyers or non-licensees, because we license more than lawyers to practice law, are not permitted to practice law. So once they approve, then they're licensed and they're subject to an ethical code, which is written for the entity itself. The lawyers are still, of course, governed by the ERs, but now the entity itself has submitted itself to licensure, and they're governed by a separate ethical code. They also submit themselves to discipline. So we have a discipline structure set up for the entity itself, which it mirrors pretty much the discipline for lawyers. We follow, I think, I call the Colorado system, where the bar essentially is the investigatory body and prosecutor that brings complaints. And then the rest of the system is set up under the court. And we have a presiding disciplinary judge and committees under that deal with discipline. Same thing now for ABS that would go through that. What could, if there's anything that happens, the possible sanctions would be loss of license, of course, suspension, or monetary fine. So the monetary fines can be anything all the way up to $1 million is what we've written so far. So there's an annual renewal every year that they have to apply for renewal. There's fees with that, just like lawyers every year, pay your fees, pay your dues, and reporting there. There's a tiered application renewal fees for application fees and renewal fees. So they range from $12,000 to international entities and all the way down to $2,000, which I think are nonprofits and maybe solos and such. And then renewal fees range from $6,000 at the high end to $1,000. And I have to say, already we're talking about revising some of that. Those are just estimates that are thrown out that would be able to cover the expense. I already think that some of it is too expensive for the low end solos and such. If you just want to, for example, maybe give your spouse a 10% interest or your long-term paralegal 10% interest in your firm, it seems a little hefty to do that for that. So we'll probably be looking at that. I've asked our committee to have a retreat type thing. Now, when we get a little bit of our months under our belt, thinking, what do you see that can be modified and changed? And already I'm thinking they'll probably propose some changes to the cost and maybe to the breadth of some of the backgrounds and such for the folks that really just want to give, as I say, a long-term employee and interest, that kind of thing. We've hired only one person in addition to what we already have. So we hired a woman named Suzanne Porter, who is responsible for overseeing that program, along with our legal paraprofessional program, which is also new. So what are the advantages and concerns? The advantages that we've talked about, that we've identified at least, is, as I said, it allow hopefully for greater technological innovations in delivery of legal services to the public. If anything, from just who you're going to partner with, maybe be a one-stop shop for particular niche areas, maybe an infusion of capital, which will allow more of an investment of technology to be able to compete with some of the tech firms and whatnot, or expand your practice that way. It will allow firms to hopefully attract the best and brightest non-lawyer partners as they desire a piece of equity or a piece of the pie, if you will, just like lawyers do. And that's what's been going on in Washington, D.C. for years. They have a modified version of 5.4. They have, there's got to be a place where retired congressmen go, right? They go to lobby and they want to be in these firms and be not an employee, but a partner. So they've allowed that. If you want to have a good lobbyist that you want to retain and have loyalty for years, same with a PR person, a business person, a marketing person, all that kind of thing. This will enable you to retain that person by giving them a piece of the action. As I said, it will allow for those kind of one-stop shopping for the consumer, and it will be provide better service to those using those do-it-yourself platforms like the LegalZooms and the Rocket Lawyers and et cetera. I know that early on in the process, I talked to, I think, in-house counsel for LegalZoom in California, I believe, and he said that, yeah, we see people all the time who will use our forms for a conservatorship, for example, or guardianship, but we can tell that they are not, they want to get control of maybe a relative's finances, but they're using a guardianship form. Well, that's not the right one. They need to go for a conservatorship, but they can't tell them that because that's the practice of law. That's legal advice of what you should be doing. So I know they've done some workarounds with law firms and whatnot, but this will allow that kind of more direct integration between the two, the do-it-yourself plus the little bit of legal advice maybe that you do need to even get in the right direction. So I'll tell you watching the clock, when we were proposing this and spent about a year to a year and a half getting input and from the bar, from our board of governors, and just from lawyer groups all over to weigh in on this, here are some of the things that I heard. One, that ABSs will not help close the access to justice gap. One, I don't believe that, because as I said, I think that it will help the smalls and solos, which really are needed to continue to help close the gap. But I think that infusing capital into or partnering with technologists with a stake is anticipated to result in more innovation than just hiring somebody to put technology into an existing practice. So for longer term, which a lot of times from my memory being a partner in a law firm, you're not thinking too far beyond, long-term investment of your monies that you could just be reaping as profits. You're not going to be doing that because you're not going to be around that long to actually reap those benefits. But people that are investing for long-term, that in the health of your firm, might be more willing to do that. I also think that ABS proposals aren't just to help with closing the gap in the access to justice. I think they're also there to help lawyers have alternatives to keep the profession relevant and competitive in a way that at least I think we've all seen slipping a bit. Consumers are figuring out how to get legal services without going to lawyers. We're losing business, frankly, and what disturbs me is that it's really outside of our established regulatory framework. So the market will find a way. Vacuums get filled and are being filled by non-lawyers and without adherence to more ethical standards and ethical rules. So finally, I think that those changes in other jurisdictions like the UK and Australia have resulted in higher lawyer satisfaction, client satisfaction, and the law firms have been able to increase capacity. In turn, the increased capacity can increase profit, but it has not been a cost that's been passed on to the client. So it's over in the UK, who we've talked with quite a bit and had over, I'm sure you have too, Crispin Passmore and such. It seems to have been a success over there that hopefully can be replicated here as well. So another complaint we heard are non-lawyer investors or owners will pressure lawyers to violate their ethical responsibilities regarding client confidentiality, lawyer independence, and conflicts of interest. Those pressures exist now. Firms exist to profit. Firms have lenders, and firms have clients. You have CFOs now that look to the bottom line. There are captured law firms or insurance companies. I mean, on and on and on. Pressures exist now, and lawyers act ethically and withstand those pressures. Risks exist, they always exist, but again, we've tightened other ERs in these areas to replace some of the language that existed in ER 5.4. Of course, our regulation of ABSs, that's part of why the court felt, this is unanimous, by the way, but the court felt that if we're going to do this, we're going to allow partnering, we want to regulate the entities. I also don't think we should assume that non-lawyers will be motivated to cause lawyers to violate their ethics just to make a buck. There's going to be consequences, including pulling the license, and complaints, frankly, are bad for business. So again, the information that we got from the UK and from Australia shows that complaints against lawyers did not increase when lawyers started partnering with non-lawyers. In other words, the non-lawyers didn't make the lawyers unethical. We heard non-lawyers can own law firms representing opposing sides in litigation. That's not true. We have ER 1.7 will specifically prohibit this, and non-lawyers with access to client information will not have a duty to keep that information confidential. Again, untrue. Just like the law firm paralegal and office staff currently, there are obligations there that will be on the lawyers and the owners to ensure that information is kept confidential. So we've currently, licensed 8, nothing compared to Utah, but we just got started really in April. We've licensed 8 entities thus far. We expect looking at the pipeline, probably by the end of the year, it'll probably be up to around 20 to 25. The first 8 are just the type of entities that I thought we would see, and that's lawyers taking advantage of this to innovate their practices. And so we have firms that have had estate planning, estate planners and financial planners going with probate lawyers to have that kind of one-stop shop. We have a few that have this wealth kind of one-stop shop for managing your wealth long-term. We have one entity that is, I think it's still just a traditional law firm, but again, they wanted to bring in a business marketing person who will be responsible for handling that side of the business and end of it, but also has an ownership interest in the whole thing. There are, let's see, what else do we have? We have something that will allow online subscription-based bilingual legal services for small businesses and consumers. So they're targeting mostly this, I think, the Spanish-speaking small businesses and such that, and they're also offering non-legal services in the form of mediation, that kind of thing. So those are just some examples of what we have so far. I could tell you, I could either do, I'm going to stop here and ask you, I can either tell you about what we've done with legal paraprofessionals very quickly or open up for questions about ABSs. I'm not sure what you're interested in.
So since there's a different group that's addressing paraprofessionals specifically, and since we're in that sense more interested in ABSs, and I'm sure I'm not the only one with questions, I want to start by saying thank you very much. And also, to the extent you were reading off of slides, if you're willing, using them as a jumping off pointer because you already had them, if you're prepared to share those with us, that would be a useful resource for those of us who
absolutely,
would love to check back and have a chance to understand more slowly, or who missed the meeting for another.
No, it was a lot of information, and I was not reading off slides actually, but I have notes here for some of the things like, oh, that's right. So I'm happy to send you my notes. There's nothing. Just don't fault me for being sloppy. But
that would be great if you're willing to make them public. And I mentioned slides only because you had said at the start that you had a deck, but you weren't going to use it.
It's not a great deck.
Okay, well, your choice, but let me just say, if you're willing to provide us with additional information that we can reference, it would be great because there was a lot here. But in terms of a substantive question, if I can take a chair's prerogative to pose the first one, can you talk to us about who you turned down in an ABS application? I understand there's certain, specific information you may not be able to share, but what kinds of people have you turned down, or would you turn down if you were to see those applications? And then relatedly, do you have a set of rules that you set up ahead of time about the kinds of ABSs you would turn down? That is to say, what's an okay ABS and what's not? Or do you basically have your committee look at the entire proposal and say, yes, this looks good, we'll take it, or no, this doesn't look good, we won't?
Okay, there's a lot of questions. So far, we haven't turned down anyone at the Supreme Court level yet. So we've had 8 come through to us and we said yes to all 8 because they all came with the committee recommendation and they were all, as I say, nothing really was that unanticipated, that unique. Now, I can't think of the specifics, but I know at the committee level, it's been more of a no, not yet kind of thing. You have not satisfied us in the application. So what our person in charge, Suzanne Porter, will do is work with the applicant saying, no, the committee has concerns about whatever the concerns are, that they weren't satisfied. I know they did unearth one, hope I'm semi-accurate on this, that person that had an ownership interest, it was but through an entity, and then tracing the entity down, it turned out to be a disbarred lawyer. So for them, they said no at that level, because that's a definite line in the sand on that. So that's the kind of thing that the backgrounds and such will bear it out, but it's mostly entirely at this point, at least, it's been at the committee level, the application level. Now, as far as what type of services, it's funny when we set up this, after the task force made these recommendations, then we had a smaller group that were more savvy on regulatory issues and ethics and that kind of thing. And so while the rule petition was pending, I knew my colleagues, and I knew that because it's a lot to take in, all these huge changes, and I didn't want to just have a memo written to them with a few weeks for them to look at it and then have to make a vote. That wasn't going to happen. So I spent a year forcing them, saying, well, I'm scheduling all of these informational times for you throughout the year. We're going to discuss each nugget so that you're well familiar by the time we have our August rule agenda. And I knew, because I would want to see it too, difficult to vote for something unless you see, well, what's it going to look like? And so we had, simultaneous to the rules petition being built out, we had this small group building out the structure, if you will, and so that it was all in place. Now, where was I going with that? I just lost myself in the whole thing. Your question was about, throughout that. So in that process, we spent this group, and I was part of it, spent quite a bit of time discussing, trying to say, more black and white of you can't have this kind of ABS and you must reject that kind and that kind of thing. Well, it really turned out to be, wouldn't say impossible, but certainly it went against the notion of innovation, because we can't contemplate what types of firms or ABSs people will come up with. We hope they'll, I hate to use the cliche, think outside the box, but that's what we're hoping for. I mean, we're lawyers, we're not all that creative. And so let's let others from different professions weigh in here and come up with something. So that's why we didn't put too many black and white, you can't do this with, that it would impact fraud, that kind of thing. But other than that, that's why we came up with, here are our objectives, and we listed 5 objectives. And up to the committee and the court to then look at what you've proposed to decide if yes, we're comfortable with that. Did I answer all the questions on that?
You did an amazing job with a big hairy ball of issues. Thank you very much. I'm going to call first on Andrew Arruda and then on Neil Gupta.
Hi, Justice Timmert. My question is really around scope. One of the things that we're struggling with a bit at times is just in terms of identifying and targeting our efforts towards low-income Californians. There are some who think that should be the emphasis, while others are thinking that we should take on a broader kind of scope and just kind of go for access justice on a statewide level. I was wondering if you could share just if that was something that you had thought about. You went with a wholesale change in the rule and it wasn't for one segment or another. So it'd be great for us to learn from some of the discussions and your thinking in Arizona as we kind of discuss that and consider that in our proposals here in California.
Yeah, sure. Well, I think we had a lot of that discussion in deciding whether we wanted to go with more of a sandbox approach or just build something that we were comfortable with. And part of the reason, among others, is I already explained of why we went with, well, here's the structure that we're comfortable with, now innovate within that structure. And here's your minimum that you have to make sure you comply with all of these things. But other than that, it's up to you to decide. Well, that doesn't, when you decide to do that, you don't target a particular segment of society. So while we're hopeful that people will come in and start targeting the people that are truly underserved, I mean, the poorest of the poor, it doesn't necessarily have to be tied to that. It can be anyway, all up and down the ladder. So, after we decided that, there wasn't really a ton of discussion on scope. I mean, we had more of a discussion there on the committee that you're not looking at, or your committee is addressing, which is the legal paraprofessionals. because where I want to go with that, and I'll just tell you, I'll give you a preview if I'm the next Chief Justice, I'm definitely going to push, is that if this is a success, having folks be legal paraprofessionals and it works and it's competent and et cetera, and to get it robust, I'd like to forget conflicts and all that for now, somehow bring them into where you would expect to find that. Where would regular people expect to find help? Well, at the courthouse. So we've been, and I'll brag a little bit, before my time I can brag, that Arizona was first in developing self-help centers back in the 90s, and we've really tried to develop that through the years. And I'd like to be able, people walk into a self-help center and be able to have either one of these legal paraprofessionals or a lawyer, frankly, and either, just give some help on, even if you can pay $50, we can control the pricing then, and you can pay $50, you can get an hour's of somebody's time to tell you, walk you through what you need to do, to where you should be going, what you need to do when you're trying to do your divorce or get a guardianship or whatever you're doing, that kind of direction for people. Because many times that's all people really need. They don't need the soup to nuts lawyer. They need just a little part of it. And we've unbundled our legal services. We did that back in 2016, another task force I chaired, that trying to unbundle services to get lawyers to be able to just give a little piece to people hasn't been terribly successful. I don't know why people, lawyers, I think family law lawyers are just starting to take off with some of that, but it's been slow to go. But that's where we had most of our discussion on scope, and that's what drove the decision for legal paraprofessionals.
Thanks.
Thanks. Neil?
Yeah, hi, Justice Timmer.
Hi.
So two questions for you. And the first is, have you folks received any complaints regarding any ABS operators in the field so far? And if so, can you offer a high-level explanation of the complaint? And second, which is not quite related, but how is your ABS committee collecting data from applicants as they're operating in the sandbox, and what kind of data are you collecting?
We haven't got any complaints so far, which is great, but it's only been, I mean, the first ones went in, it's just been a few months. So I would hope not, that they'd be on their, best behavior, even if they were inclined to do something bad. So no, we haven't got any complaints. Then data is something that we're just still discussing too, because the data that we're collecting on the front end are really from the application itself. I mean, who you're going to be servicing, and we can collect complaints and that kind of thing, that type of data. What I've been talking to them about is what we really need, though, and I'm not exactly sure how we're going to collect it either. And I know that the Center for Innovation is talking about this. How do you collect it on the back end? How do you collect it to show what's making a difference? Did this make a difference? Did this serve people? Did it close this access to justice gap at all? And that's still a work in progress. Difficult to get that kind of information, because how would you measure it? For legal paraprofessionals, it's a little easier. We can find out, how many people you're serving, I suppose, if we ask questions. But we're talking about that because we also don't want to intrude too much. Again, back to don't make this so difficult that people don't want to do it because it's just too onerous with all the reporting requirements and oversight and such. So I'm afraid that's not a great answer for you, Neil. It's certainly on our radar screen, as it is on everybody's, because data is going to drive this and drive the success or not, and if people thinking it's a success.
Okay, thanks.
John Lund, you're on mute.
I actually think Tom was up before me, Justice.
Tom, go ahead. I didn't see a hand.
Oh, thank you.
See it blends into your ceiling. Got it.
Yeah. Hi, Justice Timmer. Thank you very much for these comments. I'm curious about the compliance lawyer concept. Had two questions. One is, I understand that the compliance lawyer's ticket is on the line if there's a violation of rules within his or her purview. And then secondly, I'm just wondering how this practically has worked. Have the people who are compliance lawyers or the firms found that structure practical, useful, that kind of thing?
Yeah, well, we don't have a lot on that yet, just because, again, it's so new, but yes, you're right. The compliance lawyer's ticket is on the line for this. And so it's somebody that's going to be, you know, obviously has a vested interest in the firm and its success and such. And again, right now, the people that we've had so far are more traditional law firms, law practices that have just brought in some other aspect to it. So it hasn't been all that different from, okay, great, then a partner, the lead partner is going to be the compliance lawyer to ensure all this is done and can report out on that. Just like, I don't know if you have this in California where you have I guess they call it, they don't call it compliance lawyer, but one lawyer in each firm responsible for reporting and overseeing the IOLTA account, and that's abided by. Do you have that? Yeah, and you have to report that, and everybody has to report that on their due statement every year of who that person is, and that they've overseen it, and that, yes, the person is ensures that the IOLTA account stuff is correct and overseen. So it's the same kind of concept, and that's probably why that came up.
Thank you.
Okay, John. I confess, am I the only one getting bad interference, or is Justice Timmer breaking up for some of the rest of you?
Oh, am I breaking up? I hope not.
You were for me, but I'm not sure.
Okay.
In any event, I didn't want to be interrupting you, Justice Timmer, but if you were finished, I wanted to call on John Lund, and I couldn't tell because I got static. Seems you're finished now, so I'll turn to John Lund with apologies if I was breaking in prematurely.
Hi, Justice Timmer.
Hi, John.
I wanted to, as I recall, one of the things I think this group is trying to figure out a little bit is, you know, what do the consumers here really need and what do they want, and how do we find that out? You know, who do we ask and who do we rely upon for that? As I recall, Arizona did some polling or some surveying around consumers. Am I right about that? That's one question. Just kind of related to that. How did you interface with the practicing bar in California when you were moving these things forward?
Oh, in Arizona? Yes, absolutely. And let me know if I'm not clear. Sorry about that. That's what happens. I'm working home on Fridays and don't have my usual setup. I'm looking at my notes. This is on the PowerPoint. I would have shown you, and I'll send it to you, that yes, we went out, we hired a professional polling firm to go out and to check with the public. You know, how did the public feel about these proposed regulatory reforms? So both the legal paraprofessionals and the ABSs. And so that came out as far as the ABS, the public support for the law firm ownership changes in 2019 was 62% supported that. And then, which I was surprised, frankly, that they even could understand what that was. But I guess the polling people took me through it, and they show how they do some pre-testing and then a little bit of education on what that is, and then post-testing and whatnot. But yeah, 62%. And then for the legal paraprofessionals, 80% were in favor. So they definitely understood that with the nurse practitioner model comparison, and they want that. Then we also have what we have called town halls here. And so the town hall, which is a nonprofit, took up this issue and conducted some town halls with the people in the public, and we got back resoundingly that they're for these innovations. And then as far as how despite the fact that all of our meetings, like the meeting you're having, we've conducted all of them in public, and anybody could come, and people did, but lawyers are busy and they're not going to pay attention to the majority won't pay attention to these kinds of things until it's on their door, and then they're upset. So of course, this is a huge change, and lawyers don't like change and could feel threatened. When I first heard of the proposal back in 2012, of why don't we get rid of 5.4, that was my reaction. Oh, we can't do that. That's too much change. So I knew that would be the reaction. So we ended up having to affirmatively, or at least additionally, we still did, invite them to comment and invite them to weigh in on our online rules forum when we proposed any rules. We just went to the bar, and I know I gave a presentation the year before the recommendations were made to say, look, this is what we're talking about to their board of governors, put it in their radar screen. So you need to be talking about it. Then, and frankly, I invited myself to several lawyer group lunches and whatnot to tell them this is what's going on. And so give me your feedback, and we welcome it. And then as we built out the structure, told you, I wanted to have both structures built out before my colleagues and I took a vote on it as we went through, because they made great suggestions. So we tried to do what we could to involve the bar as much as we could. We went back to the board of governors after the rule petition was filed, said I'm back. Now here's the presentation, and had a rather robust debate. And I was actually, I was surprised that they voted to support it, not unanimously, but the majority. So I feel like it was that year-long effort to really let people chew on it and talk about it. That really probably won over the majority of folks. And again, our board of governors, I don't know if yours does, we have public members on our board of governors, and recalling the vote, it was really the public members, one in particular, that pushed the ball over the goal line for them, who said, look, we need this in the legal community. So that was very helpful.
Thank you. Eric.
Thank you very much for this. This was incredibly helpful. I wanted to just turn, you mentioned something about fees, and I was wondering actually how you financed the mini sandbox. We've been having I guess what I'd call a chicken and an egg problem. How do you sort of get this started, and what sort of funding sources you used? And then you also said you were adjusting the fee structure, and I wonder kind of where you got the fee levels initially from.
Well, we got the fees, I believe, was more people on AOC that were experienced, obviously, than I am on our other licensing efforts. And so we had a pretty good idea of, well, what does it take to check out some of these entities and do the background checks and all of that. So I believe they just took that from that experience. And then I'm sure there's a little bit of spitballing going on, thinking, well, what will it take here? What are we requiring? And that kind of thing. And so that's when I say that inevitably they'll make adjustments. I think we set it a little too high, if anything. But again, it's meant to be a self-sustaining program because we don't have grant funding. I think Utah's Sandbox has grant funding, and grants run out at some point. And so our experience in the past, when we've had pilots and whatnot, that if they ever depend on grant funding, that's a problem, because they're inevitably it will run out unless you can get funding from your legislature on these things or some other source, but it needs to have a consistent funding. So lessons learned mostly from our director of AOC, who some of you may know, Dave Byers, who apparently is the longest serving AOC director in the nation. So he's been around the block many times on these things. And he's the one in my ear, or not literally, but figuratively saying all the time, no grant funding, it has to be sustainable. Programs have to be sustainable. So I think that's part of what pushed us to on the out of the sandbox. If we do a sandbox, and I suspect we will, on just a mini sandbox, it'll have to be either money we can find in our drawers somewhere, or some kind of grant funding, maybe from SJI or wherever we're going to get it. But again, it can't be long lasting.
David Engstrom has the last question.
Oh, wow. Hi, Justice Timmer. Thanks for being here. This was really helpful. I have a two-parter. The first question is, you mentioned in your presentation that you had a separate ethical code that applied to non-lawyer participants. And so this obviously connects to the topic that we were starting to discuss probably right as you came onto the Zoom, which is what legal ethical rules, if any, should apply to non-lawyer entrants to a proposed California sandbox. I just looked at the materials that were circulated, and Section K has a code of conduct that indeed sets forth obligations for non-lawyers within ABS structures. And I noticed in some cases you mention an ER, but in other cases you don't. And so I'm wondering if there was any reason to do it that way, rather than doing what we were discussing as you came on, which is just say, hey, these rules apply, these particular rules apply in full to any sandbox entrance, anyone who's providing legal services within the confines of what we're doing here. So that's the first question. But let me ask a second one. I am a staunch believer in asking the question that may end up sounding really dumb, because there may be other people who are harboring the same dumb question, but just ask it. So let me roll, which is, what's the difference between what Arizona did and a sandbox? In both instances, you have an entity that's deciding who comes in and who doesn't, that's essentially presiding over the dishing out of waivers of various rules that would otherwise apply and maybe prohibit the services in question. So what to your mind is the difference between the route that Arizona went and, say, the route that Utah went and that maybe California is considering going?
Oh, okay. You a little bit too, but hopefully I'm not. Utah have talked about this, and really there's not huge differences. It's just approaching the issue from two different directions. So the two differences that I see, my internet's unstable, that's probably why problem. The two differences I see are this. One, as I mentioned before, that the sandbox allows participants to practice law who are non-lawyers or non-licensees. We don't. So you still have to be a lawyer or a legal paraprofessional or one of the other exceptions we have to be able to practice law. And my understanding of the sandbox is that that's not so. The other difference is that while in a sandbox, you could look at whatever the proposal is, and then you make certain requirements based on what's proposed. So it's really tailored, whatever you're requiring would be tailored to the particular applicant, saying, well, this is what we want you to do, and this is your reporting requirement, and this is will allow, I don't know, this, but not that. Whereas we're not that tailored. Ours, we're more off the shelf in terms of if we allow you to participate, well, here's everybody is treated the same. Here's what you have to abide by. So whether you're the tech firm or the lawyer who wants to partner with the financial planner. So it's just that's really different. But in the end of the day, David, I think your probably your instinct is correct that there's not a lot of differences in the end of the day. The end of the day, it's something new and it's allowed to practice and it's still regulated by the court. But my impression is that, and I'm going to guess, and so I know that Becky, who's on Utah, and she'll correct me, if not in my presence afterwards, that I'm going to guess that Utah is not going to sustain this sandbox forever, at least with lawyers that are practicing, because it's not sustainable probably financially. And they'll end up taking the best of what they've learned through the sandbox experience and conducting some type of permanent regulatory structure like we've structured already, that's what it will lead to eventually. So there's just two different ways to do it. Now, as far as the ethics, I wish I had a better answer on that, but lawyers are still by ethical rules. So there's nothing that's changed for a lawyer, whether you're in an ABS or not. So really what the other parts of it for the non-lawyers are simply things that are designed to ensure that those folks have to abide by rules that will enable the lawyers to practice law and ensure things that are primary, absolutely necessary for that, which are avoiding conflicts, ensuring client confidentiality, that type of thing. But we're not putting on non-lawyers the full ethical responsibilities that a lawyer would have to abide by, because they don't all apply to non-lawyers. The legal paraprofessionals that we're licensing, they do have to abide by all of them, except I think one that might be unique to lawyers, but that's the difference.
Well, thank you very much. There were so many questions because you had so many interesting things to share with us. And I really appreciate you coming in to share Arizona's experience and your hard work and great success over recent years, making changes in your state. So thank you. And
No, you're welcome. And I applaud all of you for all your good work and hard work. So good luck to you, and whatever good things you come up with, we'll steal the best parts because that's what we do. And then Allison, who would you like me to send? I'll send you my PowerPoint and
I think you were you communicating with Randy DeFontorum ahead of time?
You know what? I'll send it to my JA, who will know what to do.
We will reach out to your people and let you know who is looking forward to seeing your notes or your PowerPoint or whatever it is you're willing to share. But
Whatever
mostly thanks of all for sharing all your wisdom today.
Oh, my pleasure. Y'all have a nice weekend.
Thank you. You too.
Bye-bye.
Goodbye.
Bye.
Goodbye. I'm going to give us all a 5-minute break. We will come back at 10 minutes after 3. And when we do come back at 10 minutes after 3, we'll be on Micah's question and David's answer, and more generally on the last agenda item from this morning's agenda. And after we finish that agenda item, we will circle back to the 2 rules presentations that Kevin was involved in that we didn't get a chance to do before the presentation. So see you all at 3:10. Thanks. Welcome back, everybody. That was really a terrific presentation, wasn't it? So Micah is there. Micah, you had questions and you only got your first one in before we broke at 2 o'clock. So if you remember what your next one is, please have at it.
Yeah, well, you know, it's not so much a question anymore. I mean, I think what's become clear is, and we just heard from the justice that some people's perspective is it's okay for there to be 2 sets of rules, that the corporations or other non-law corporation entities in the sandbox can have a different set of rules, higher standard, lower standard, or whatever. So it really has just kind of become a comment at this point. You know, having lived through the data breach and privacy legislation battle that was in 2018, well, it started long before that, and then the statewide proposition and the fight, and knowing how the legislature feels about the protection of consumer privacy. Not that I speak on behalf of Tom Umberg or Mark Stone right now, but I think it would be a hard sell to suggest that the non-law corporation entities, if they're below a certain size, or even if they're above a certain size, can sell even anonymous data. You know, it's also become clear that this committee or certain members may not have a big appetite to hear about what the legislature thinks or what it wants. So I'm really just saying that to share my perspective. So if this comes up for a vote, obviously I'm not saying how I would vote, but I think that if lawyers can't sell even anonymous data, other entities shouldn't be able to either.
And Micah, I guess I'll let David Engstrom respond to that comment.
If you want to, I mean.
If he wants to.
Yeah, I'm not challenging your perspective. Right. I'm sharing mine.
Well, I guess what confuses me about your perspective is, and so I guess I'll pose it as a question to you, Micah. Do you understand anything in David's proposal to be inconsistent with what you just said about commercializing consumer data? Because I don't.
Okay, maybe I got it wrong then. I thought what you were saying, David, was that if a lawyer would not be able to sell consumer or client data, but a sandbox entity that was not a law corporation, I'm assuming, would be able to. Did I get it wrong?
No, I think our proposal is to bring both lawyers and non-lawyer entrants within the sandbox into phase with regard to their obligations under, say, Rule 1.6, which means if you get evolving judicial interpretations of 1.6 or a set of ethics opinions with regard to 1.6 that permit certain types of commercialization, presumably with all sorts of assurances about anonymization, that there won't be any actual confidential client information revealed, that if the law and the interpretations of the rules evolve in that way, then both lawyer and non-lawyer entrants to the sandbox would be able to engage in that limited commercialization. The point is to make them equal across lawyers and non-lawyers, and to hitch the sandbox rules to wherever the law goes in this regard over the next 4, 5, or 6 years.
And in that regard, would it also be fair to say then that if there were to be further revisions to the rules that said that lawyers could not, even with client permission, commercialize data, that those rules would apply likewise to lawyers and to non-lawyers in the sandbox?
Yeah, here's one way to frame it, I suppose, which is we could propose that there be some sort of a flat bar, some sort of a flat prohibition on commercialization of data. But what we could find then is that over the next 3, 4, or 5 years, the evolving interpretation of Rule 1.6 could allow lawyers to engage in very limited commercialization, again, with all of those assurances. And then we would end up with sandbox entrants who can't do something that lawyers are permitted to do under governing interpretations of the rules. And that seems inconsistent with the innovation purposes of a sandbox. It seems strange to set up a sandbox then in which there are even more onerous requirements placed on sandbox entrants than would apply to lawyers who are fully complying with legal ethical obligations as interpreted by all the relevant authorities.
And
go ahead, Micah.
Well, let's just dumb it down for me, because it's the end of the day. Let's say everything gets through the Board of Trustees and you're suggesting statutory language about the commercialization of consumer data. Is the statute going to read the same for licensed members of the bar as it would for anyone accepted into the sandbox?
Yes.
And what about corporations outside of the sandbox who haven't been accepted into the sandbox?
The sandbox wouldn't be regulating those, presumably.
I don't think we would be allowed to say anything about those.
Okay.
I apologize that I took my video off. My internet was unstable, so I'm present. You just can't see me. John Lund has the next question or comment, but is on mute.
I just wanted to say that I think this is a really smart approach on this piece because things may indeed evolve. And kind of as a related point that I just hope doesn't get lost in the shuffle, I would say we've had no applicants who had some concern about, the idea that they couldn't share consumer data. In fact, at some level, these concerns over privacy and proper maintenance of a consumer's data are much broader than the law and probably handled more effectively by people other than lawyers in some settings. So we've never, and it doesn't seem to be creating a burden on providers. But I do think that's an important thing to remember is every time we kind of ratchet these rules up, we may be deterring people who would otherwise come in and provide a service that would be valuable and accepted to people. It may feel like it's a first aid or a band-aid solution for someone, and it's not the best solution that they could get from a lawyer, but it's better than what they've got. And as long as it's safe, I think we need to make room for that. And I think we need to avoid having the rules write cost into the provision of the service that genuinely are not what the customer or the client needs. So anyway, that's all I have to say.
Thank you. Eric.
David, this is just a clarifying question that probably reflects my ignorance of the law, but for an involuntary breach, do law firms currently have a higher standard than just any other commercial entity? Did I understand that correctly? So that there's a greater punishment than for I don't know, I'm trying to think of Sony breaching privacy data. Is that correct?
I can't tell you whether it's higher. I can tell you that law firms are subject to Rule 1.6, whereas non-lawyer owned corporations just doing, standard commerce stuff out in the world are not. And that Rule 1.6, which is a broad duty of confidentiality, includes a duty to take reasonable precautions to safeguard a client's data. And so
I don't have any.
I don't know whether that's higher or lower. We would have to do a ton of research to try to make that kind of a determination as to the comparative rigor of the two. But yeah, it is a different body of requirements.
So just to follow up, in the part of a business entity that would be providing legal services, they would have to comply with the different, maybe higher, maybe lower standard. Is what we're saying.
Yeah, I think that's right. And so you can imagine a multidisciplinary provider that's doing a lot of things, and it's doing some things in one corner of the entity that have nothing to do with the provision of legal services, then for sure they would be subject to all of those non 1.6 requirements. And so that includes common law prohibitions in a sense, which is to say that, if you can get past all the standing and other problems that we know exist in the data breach context, like, a plaintiff can sue you for failure to safeguard their data in some relevant way.
So can I ask whether that response suggests that you are accepting a friendly amendment to the language of your proposal, at the end of the first sentence where you say will apply in their then current interpretation the rules and statutes to all entrants to the sandbox? Do you want to add language that says in their provision of legal services? Because if you've got a sandbox entrance that does legal services and other things, it only applies in legal services? Or do you not want to cut that finely? And in fact, if you're getting into the sandbox, it's going to apply to you across the board?
That's a hard question, and one that I would want to think about. Maybe others have views off the cuff about the merits of those two approaches.
Okay, while we're thinking about that, Kevin had a comment. Kevin, you're up next.
Yeah, I have a question about that. I think lawyers, because of our duty of confidentiality, do owe a very high duty with respect to data breaches to take particular cautions we're not just talking Rule 1.6, but Rule 1.1 that deals with competence to protect the confidential information. Now, I'd be real concerned about a participant in the sandbox who I'm presuming is going to not just be providing non-legal services, but would also be providing legal services. Then that information, any information they collected by virtue of having provided legal services, somebody came to them for legal services, then they are under a duty. They have to be under the same duty to protect that information. So I guess because I think Eric's question dealt with data breaches, that set alarm bells off to me. And I wouldn't want to limit this just to when they are providing legal services, because that narrows it a little bit too much.
Okay, Eric Helland had the next question or comment.
I think there's just to agree with Kevin. I suspect that's too big a loophole, just off, again, the non-lawyer commenting here. But if you have, the standard is pretty low for data breaches, from what I understand. It's a very hard one to prove because it's usually some sort of illegal activity. And so, I think that the case law that I've seen on this is literally leaving unprotected in an unlocked shed and things like that, right? So I almost wonder if we want to leave it out just to say, that if you have an entity that's providing both, it has taken on itself this higher duty of care kind of across the board, because I wonder if it would just be too difficult to separate out, kind of as Kevin was suggesting, the legal services from the non. But that's off the top of my head, and I'm not a lawyer.
Micah.
Thank you. I don't know why I don't know if y'all are having the same Zoom issue, but I can't see if my hand is up, and
I see your hand.
Okay, good. And right now it says I'm still muted and my camera is off, but I can see myself. So I don't know what's going on. So I just want to kind of bring this down a level. We're saying So the two ways lawyers can be held accountable for a data breach is, a private right of action and a civil suit. They can also be disbarred potentially if they fail to comply with any of the rules that apply to them. So are we suggesting that if a non-lawyer entity that's in the sandbox breaches what otherwise would be an ethical rule, that's a ground for discipline to kick them out of the sandbox? Or what's the penalty? Or are they only exposed to a civil case and a private right of action for that kind of misconduct or unethical behavior?
So if I could suggest an answer to that, is that we aren't answering that question right now. We will look separately at the process for throwing someone out of the sandbox or suspending them temporarily or fining them money or whatever. But all of those consequences, as well as having this rule cited in your 17200 case, would be consequences of an entity breaking this rule. At this point, we're not going to the next step of saying exactly what the sanction would be, but we are saying this is a rule we expect everybody to comply with.
So there will be a sanction. There will be some.
There will be a separate discussion of sanctions. It won't be specific to this, to breaking of this rule. It'll be about all the kinds of bad things that could cause people to get thrown out of this, or thrown out of, or otherwise sanctioned in their participation in the sandbox.
Right. I'm not asking what the sanction would be. I just want to know, are we tying some sort of penalty to a violation of an ethical rule? Is that was that your whole point, David, that we're leveling it all up, which means there will be some sort of remedy, whatever it is?
Sure. And if I can just echo, I think what Justice Duker just said, we need to put into place a disciplinary system of some kind. We don't know what that looks like just yet because we haven't built out that part of the proposal, but that a sandbox entrant who violates 1.6 or 1.1b in their failure to take reasonable precautions to safeguard data will be subject to whatever disciplinary process we put into place.
Mary, you're next up. But you're on mute.
I know, sorry. Thanks. On that point, I think the point that David just made goes to, we do need to figure out, and I thought this was sort of in stages, camp in terms of figuring out discipline and enforcement. So if we're starting to get a little slippage between the committees, which is fine, but we need to figure out who's doing what. But we certainly do intend and have on our agenda to figure out a whole, series set of like how entities will be disciplined and sanctioned. So, to your question, Micah, will there be? Yeah, there's going to be something, of course, right? This whole point here is public protection, and I'm not quite sure why you don't believe that, but in any event, my question goes to the point 2 on the memo. Piercing confidentiality and privilege. It's not really a term that we use when we talk about how confidentiality and privilege applies. And I only raise this because, for example, the state bar can't just decree that confidentiality is waived. And so, for example, if the state bar were investigating a lawyer, if the client complained, then the client, by making that complaint, will have waived the confidentiality and privilege protections. But if a third party complains about a lawyer, for example, all the rules of confidentiality and privilege still apply. So I don't care what term you use. To me, I don't know what piercing means. And I just want to make sure that we're not creating some different standard than already exists, for example, within the state bar.
Well, if I can jump in here, it may be that the proposal needs some editing, refining, or changing, or maybe it turns out not to be well advised. But I think the reason that we put this in here was because some level of auditing the performance of entities in the sandbox is part of our vision for consumer protection. And that suggests that we, for example, would be seeking to figure out how well a sandbox entity is serving its clients, separate and apart from responding to client complaints. And we wouldn't want to encounter a wall of, we won't answer your questions, attorney-client privilege won't let us. So the point of this recommendation is to ask that the legislature create an exception to attorney-client privilege with appropriate safeguards. We're not trying to let anything get beyond the sandbox investigators, and would want to make sure that the clients are protected, but we would want to be able to have the sandbox auditors get useful information in performing that work.
Well, I understand that point. And of course, it's really not privilege that's primarily implicated here. It's really confidentiality, which has both a statutory component, going back to our legislative issue, as well as a rule of professional conduct. So, with that, here we go back to the Supreme Court and the legislature. And I do get that. And maybe if this is just a placeholder, resolution, then that's fine. I just want to make the point that to me, it's not crystal clear on its face. And I think we do have to develop it further, but that's fine if that's what's intended.
So any suggestions for friendly improvements would be welcome. But in the meantime, Wendy and then John.
I think I'm going back to a couple of points, and I'm sorry if I'm going backwards. I was late in the line of lines of hands. With respect to the issue of having one standard or two standards for corporations and lawyers, I think it's literally unworkable if you had two standards. You have a single entity, right? And if they provide both types of services, chances are logistically they're structured in a certain way with like a single set of like hardware and the way the systems flow with each other. And to say that they have two different standards would require two full-blown separate sources of how those things go. And I think that's really, really difficult to do. And I just think it also creates difficulties in enforcement. And I think it would be almost impossible to be able to do that kind of tracing. I'm not technical, but I don't think that it is possible to trace it like that. And so you would have to put them up to, I think you needed to put them into one standard. And having done a lot of, and I'm sure Mary does this too, where you advise law firms when they are entering into tech contracts, and you review all the tech contracts, and all the tech contracts are they're written in such a way that have nothing to do with the professional rules, professional conduct, and there's almost no negotiable way of making those contracts comply. And so if you have, chances are the corporations will be coming in to the sandbox with something very similar to that. And to have those two sets of standards that are so divergent, I think would create, I think, some discrepancy and what is the word when you have two and they're treated differently in the same box. And that's just not something that I think is fair. And so I think it should be a single standard. And it should be the lawyer standard. And John, I think that it's not too much of a price to pay. That's the price you're going to pay for getting into the sandbox. I don't think it's too much to ask.
Thank you. John Lund.
A couple comments. One, on the question of data flow, we've tried to just have it be anonymized data that comes back in so that we're not really invading attorney-client privilege or other confidentialities of the clients that the sandbox participants are serving. So maybe that piece, can be worked on a bit. But Justice Tucker, my main reason for raising my hand is I don't know exactly where we are from before the break, but even though this is worded as having to do with application criteria, I guess I would make a motion that the group approve recommendation number 1 as written as a policy to be applied both in applications and otherwise in the sandbox.
Okay, we have a motion.
Can we put it back up? I'm sorry, it'll help a lot.
We'll have the language put back up.
I'll second the motion.
That was Toby seconding it. A question of clarification before we figure out if we're ready to vote. First of all, this is just recommendation number 1. For now, we're leaving recommendation 2 off for further refinement, right?
That's my motion.
And then secondly, David had suggested that there was an open question as to whether we would give the attorney, we would recommend that the attorney-client privilege be given the same sort of leveling up treatment that these ethical rules were given or not, and that wasn't specified one way or the other. So your motion doesn't address that. We would address that point separately. Is that also correct?
That is.
Okay. Any discussion on that motion? And I see Greg's hand raised.
Yeah, I just want to just bring up, can you hear me okay?
Yes.
Okay. I just want to bring up one point also, just embedded in some of these rules, of course, is the exception if a client provides informed written consent. And that term is defined under Rule 1.0.1E. And it is more than making boilerplate disclosures, having somebody check a box, and that would not necessarily conform with the definition. So I know that that rule is, it referenced in these other rules as well, 1.6, for example, but I don't know if it's worth making that clear in this motion, because the definition of an informed consent really requires, in this case, a lawyer to gather a lot of specific information to that client and make very tailored disclosures to that client about the potential risks of the course of conduct that's being proposed, and making sure that they're informed based on those relevant circumstances.
So that point is going to be important if we were talking about the broader point of, whether the rules allow for commercialization of data. But you're making the point just because you think it's
I'm making the point,
I'm not sure why you're calling it out. That's my question.
I'm calling it out just because it is relevant to, if we're talking about, we're going to vote that we're going to level up the non-lawyer participants, that we're also including all of the defined terms that are referenced in those rules, because it goes beyond just the list of rules that we have here.
Okay, so your friendly amendment would be just to add the concept that this includes all the relevant definitions
under Rule 1.0.1. Yeah.
And if you want to say including in particular such and such, I don't know. But if you can say what your amendment is, we'll see if it's accepted.
I would remove probably and before 1.9. And replace it after just before business and profession code, and the relevant defined terms under Rule 1.0.1, because there actually are more than one term. There's a separate defined term for what is written consent as opposed to informed consent as well.
Isn't 1.0.1 in all of its terms incorporated by reference, because there's an asterisk?
Right.
So I'm not sure it's necessary to go beyond where we're focusing on the duty of confidentiality here.
As long as that's the understanding of everyone, because it's going to require more than what we normally would conceive of when people waive their rights to having their data disclosed.
Yeah, you made that is a really important point you made, Greg. I'm not sure it's necessary.
Yeah, I'm not really even recommending that we amend this. I just want to make that point, because I think it's important, especially for those who are concerned about the disclosure of client information. What would be required of these Sandbox participants before they were able to use this data?
Okay, so you're not asking for a friendly amendment. You're just making an explanatory comment for people to be aware of as they think about this. Yeah. Got it. Thank you. Are there other, David Engstrom?
Could we put this is a friendly amendment and a very short one, the shortest possible friendly amendment. Could we put a dash between then and current?
Yes. A hyphen?
Yeah, that's my own tortured language. And I think in my mind, it was a then current then dash current. And that's just incredibly important. It helps to create that hitching effect that I think is one of the principal virtues of this approach.
Done. Then we have a motion and it's been seconded.
Are we missing an and here before business and professions code, or was that intentional?
I think we put in an and before 1.9 and we should take that one out. Is that right?
Well, I'm just saying because you're listing recommend that rules.
I think you can have it in both places.
Oh, yeah,
I think
yes.
so. Okay.
Okay. Anything else before we call the vote? Hearing nothing, Mimi, please poll the members.
All right. Marta Alkenbrock, Andrew Arruda,
Yes.
Judge Irma Asbury, Mary Baldwin,
Yes.
Judge Wendy Chang,
Yes.
David Engstrom,
Yes.
Tom Green,
Yes.
Dan Grunfeld, Eric Helland,
Yes.
Kathy Huang, Micah Star Liberty,
Yes.
John Lund,
Yes.
Kevin Moore,
Yes.
Wendy Mussel, Kristen Passmore, Toby Rothschild,
Yes.
Becky Sandifer,
Yes.
Jim Sandman,
Yes.
Patricia Scutero,
Yes.
Sasha Steinberger.
Yes.
Thank you. Motion
Super,
carries.
more unanimous action. I like it. May I suggest that we now move to the related subject of whether the attorney-client privilege should be treated the same way as the ethical rules that we just discussed. Wendy Chang has a comment.
I guess my first reaction to that is if you don't, then just having a duty of confidentiality doesn't really do that much. Another party can subpoena those records. And if the person were to come to court and say, well, give me a protective order because there's a duty of confidentiality, I'm not quite sure what I could do with that. If there's a privilege on it, I can bar it from being protected. But if it's not a privilege and it's just a duty, I don't know how that can be enforced from other people coming to get at it. And with respect to recommendation number 2, if you don't allow that to the regulator and you create like this little, almost like this little bubble of information within that, then I'm not sure what would prevent competitors to the sandbox or just commercial competitors from subpoenaing the regulatory agency and getting all this information.
Thank you, Kevin.
Okay, I concur with Wendy 100% on the need for some kind of a privilege. I just want to throw in an add that privileges in California can only be created by the legislature. So we're going to have the legislature involved in this entire process to determine the scope and the extent of the privilege. The other point I want to make as to recommendation 2, which Wendy raised, is that as a general rule, the concept of selective waiver of a privilege is not recognized in California, neither the state or the federal courts. So it is, to a certain extent, if the information is being compelled by the government, and we're talking about a government regulatory entity, then it's not a voluntary disclosure. It won't be a waiver of the privilege, and therefore the privilege would still stand against the rest of the world. And in the case of the Sandbox, it would be, say, Sandbox competitors, so that even if information is disclosed that would otherwise be privileged, assuming the legislature would approve and establish a privilege within the Sandbox entity, then under those circumstances, the disclosure of information would not be a waiver of the privilege against the rest of the world or competitors, but that would have to be made explicit somehow. I'm not sure how we do that, other than would be within the rules of the regulator itself, where we might have to get the legislature's sign off on that.
Thank you, John, and then Neil.
It seems like we're sort of talking about two things at the same time, which is won't be the first time. But on the subject of the attorney-client privilege, I guess it seems like the consensus seems to be we would like to recommend that the legislature establish a privilege for clients of Sandbox participants that's on a par with the attorney-client privilege. And if that's the consensus, I'd be happy to make that motion. On the question of like the Sandbox regulator getting data and information about things, I'm wondering if there's a parallel to be had from the bar enforcement proceedings, in terms of what happens when the bar needs to get information about an attorney-client representation in order to fulfill its enforcement regulations, and if we could model that for the Sandbox.
Thank you, Neil.
Sort of follow up on what John just mentioned. So, if the point of recommendation 2 is to make clear that if complaints get received by the Sandbox regulator, that the regulator has the ability to then dig in deep and determine what happened, then if that's the main purpose, then actually going to John's point, I think that when you look at a regular complaint that a client may make against their attorney, that in doing so, the client is right off the bat waiving their confidentiality and maybe attorney-client privileges by making this complaint file, right? And so if that's the case, I'm not even sure if we need this recommendation.
So I think recommendation 2 was supposed to go beyond the investigation of complaints.
And also collect data?
To reach auditing and other more proactive investigation of the performance of a Sandbox entrant. Right. But it is clear to me that it needs further work and could benefit from the insights of those of you who know a whole lot more about this than I do. So at this point, I think we don't have a motion on the subject of recommendation 2. We have take that back to the drawing boards and think about some of these issues. But the motion that I heard John make, while not reduced to writing, is I think that we recommend that the legislature extend the protections of the attorney-client privilege to clients of the clients of Sandbox participants. And here I think we might need to say in the provision of legal services, because I don't think if a lawyer is practicing with a tax advisor that we necessarily want to ask the legislature to extend attorney-client privilege to the work of the or a financial advisor or a social worker or whatever else that we would probably do want to say legal services. Is that your motion, John?
You took the words right out of my mouth. So moved.
Okay. Do we have a second for it?
All right. I just, for clarity, what is the motion, Justice Edmond? Sorry, Justice Tucker.
We recommend the legislature extend the protection of the attorney-client privilege to clients of Sandbox participants in their provision of legal services.
I'll second that. This is Judge Chang.
Judge Chang has seconded it. Do we have discussion further? Okay, so we recommend the legislature. There you go.
Could I request a friendly amendment?
Absolutely.
That the privilege doesn't apply to the clients, it applies to communications.
Communications, thank you.
Between the client and the Sandbox participant.
Yes, I thought something was wrong in my own formulation. It's good to have an expert on board. Micah does not have her hand raised. It was for a minute. I wanted to be responsive, but it looks like
Wendy said my point. Kevin,
okay, good. Wendy, is your hand still raised?
Yeah, I just wanted to say that this is kind of analogous to, I think, a few years back, the statute was amended to extend the privilege to lawyer referral services. And so I think this is very, very similar, and it should be non-controversial.
Let's hope. Randy.
So along these same lines, I think the concept is understood by everybody that it's on substantially similar terms as the existing doctrine of the attorney-client privilege for lawyers. So if the use of the word clients in the recommendation is used in the way that it's used in the evidence code, then it includes even people who are consulting with a Sandbox provider, but then ultimately don't hire them. And also there are exceptions to the privilege, revealing information to prevent a crime of death or great bodily harm. And all of those, I don't want to call them baggage of the privilege, but those ornaments of the privilege need to be incorporated here as well, I think.
Okay, so you are suggesting a friendly amendment, or you're about to suggest a friendly amendment that says something about subject to the same requirements and exceptions as for the existing privilege or something? I don't know. I'm obviously doing a bad job of trying to put that in words. I'm not against your concept, but it helps to be concrete.
Recommend that the legislature extend the protection, or I don't think we have to be.
Or perhaps this fits into the category like an earlier comment that Greg made, that you are sharing this information for all of us as background, but we don't need to put it into the text here.
If that's the feeling of the body, I think, yes, the explanatory report would say that that is the meaning of this recommendation, that it brings with it all of the terms that are found with regard to the attorney-client privilege.
Let's do that, because leaving that for explanatory report would be consistent with and parallel to the treatment of Greg's comment about definitions that are important to the meaning of the rules, but that we're not expressly calling out.
And the protections of the privilege are subject to the exceptions.
Right. Okay. I believe we're ready to vote on this proposal. Seeing no hands shoot up in objection. Mimi, please call the.
Sorry, I had my hand up and I see Greg's hand up.
Oh,
too.
I'm so sorry.
No, it's okay. I really appreciate Randy's comments. There's an entire body of law, case law out there where there are different permutations about when privilege applies, who it applies to. And I appreciate that we're having the conversation just so everyone knows that when we use this term, this is how it's being defined in the context of what the state of the law is. But I don't think we need any additional language, just as long as everyone understands that it's more than what's in the code.
Thank you, Micah. And I apologize that I overlooked your raised hand. And now that I see you on my screen, I also see Greg has a hand raised.
And this may be, again, more informational than anything else, but it strikes me as this may be difficult to, it's not always this clean how the information comes in potentially to an entry. I can imagine multidisciplinary practices in the Sandbox in which you have one point of contact and you're gathering information. Some of it's going to be used by a real estate broker. Some's going to be used by an attorney providing legal services. And to what extent, when you share that information with somebody who's not providing legal services, have you waived privilege? And it's whether or not we need to do anything about that later on down the road, because I don't see this as being always so clean in terms of putting this information in this bucket for legal services, this information in this bucket for other services that may be provided.
I think you're exactly right, but I suspect that we can put that off at least for a time. Kevin?
Yeah, just quickly to add informational purposes for people who want to make a vote today, this afternoon. On Greg's point, the Ninth Circuit just came out with a case, I think it was Tuesday, in grand jury proceedings, which says it's the primary purpose test is applied to the privilege in determining whether the privilege will attach or not. Now, it follows California law because there are a bunch of California cases which say the same thing. When there's a communication that, you know, has multiple purposes, what the courts look at is the primary purpose for making the communication determine whether the privilege applies. So that might be help, but we can explore that later. But it's mostly just our background information we've been giving to enable us to take the vote, an informed vote.
Thank you for that comment. And I hope that State Bar staff is capturing enough of this content in your notes that whenever someone ends up coming up with actual report text to fall behind, you know, to buttress these specific recommendations, that will include some of these really excellent points people have been making. But I think we may be ready to call the question and go through the vote on this attorney-client privilege motion. So if you do that, Mimi.
Sure. Marta Alkenbrock, Andrew Arruda,
Yes.
Judge Irma Asbury, Mary Baldwin,
Yes.
Judge Wendy Chang,
Yes.
David Engstrom,
Yes.
Tom Green,
Yes.
Dan Grunfeld, Eric Helen,
Yes.
Kathy Huang, Micah Star Liberty,
Yes.
John Lund,
Yes.
Kevin Moore,
Yes.
Wendy Musell, Crispin Passmore, Toby Rothschild,
Yes.
Becky Sandifer,
Yes.
Jim Sandman,
Yes.
Patricia Scutiero,
Yes.
Sasha Steinberger.
Yes.
Thank you.
Okay, thank you all. That was super. The agenda, I'd like to now pivot and return to the two of the four reports from our rules teams that we didn't get to this morning. And Kevin, you are involved in both of these. In one case, it's you and Patricia, and another it's you and Marta. I know who's presenting as between you and Marta. I don't know as between you and Patricia. But why don't we do the 5.7 discussion and then the 5.4 discussion? If you could kick us off on that, Kevin.
Okay, the 5.7 discussion really grew out of the ADL's task force. And to give a little bit of background about the ADL's task force, there were three different subcommittees. One was the unauthorized practice of law / artificial intelligence. A second subcommittee dealt with alternative business structures, multidisciplinary practice. And then a third was the rules committee, on which I was working. I was a member of that subcommittee. One of the earlier meetings, some of the non-lawyers in the ABS subcommittee and the rules subcommittee asked, well, is there any way that technologists and lawyers can get together and work together on a project involving technology, the ADLs being access through innovation of legal services. And we had a big emphasis on technological responses to the justice gap issue. And the Rule 5.7 came up in both of those subcommittees. Andrew Arruda and I drafted a memo regarding that, working off the work that had been done early on by the Rules Revision Commission back in the mid-2000s. I think it was around 2005, 2006 that the work was done, and it was eventually abandoned because the decision was made by the Rules Revision Commission at that time that California already had a rule, or not a rule, but they had case law that adequately addressed that issue. Subsequently, the second Rules Revision Commission, which was impaneled in 2016 and drafted the rules that were eventually became effective at the end of 2018. that they were on a short string, a short timeline. And they decided, given the nuances of California case law, that it would be too difficult to draft a Rule 5.7 in the amount of time we had. So they decided not to do it. So the ADLS subcommittee went to work using drafting a rule based on the work of the two rules revision commissions. It was put out for public comment in summer of 2019. We got something like close to 100 public comments on it. And then we went back, the ADLS task force went back and tried to redraft the rule and make some changes to more simply address some of the issues. The whole point of doing a Rule 5.7, it says non-legal services, we're talking about closing the justice gap. Legal services is just trying to get some maybe law-related services, working with technologists to develop technology that might be able to be grafted onto the problem of providing legal services, the one to the many. And we came up with the attachment to the memo. I think it's called, it's not Appendix 9. Okay. I might need some help from the State Bar staff to find which copy of the rule, which we added a provision that essentially it was paragraph D